appeal Yemshaw and the London Borough of Hounslow.
Now, Ms. Leaven, I gather you've very kindly agreed a timetable.
We have, my lords, yes.
Yes, thank you very much.
And we will all do our absolute utmost to stick to it, although there is, of course, an element of spurious accuracy in such precise timings, but we'll try to come in within rather than
just
without.
See how we get on, but thank you very much.
My lords, my lady, I appear on behalf of the appellant in this matter, Mrs Yemshaw, together with my learned friend, Mr Hodgson. The respondent, the London Borough of Hounslow, is represented by Mr Drabble, Queen's Counsel, and Mr Feldman. The first intervener, the Secretary of State, is represented by Mr Morici, and the second intervener, Women's Aid, is represented by Mr Naffler, Queen's Counsel, and Mr Jeffs.
Thank you.
As your lordships will be well aware, this appeal concerns the meaning of the phrase domestic violence in section 177 of the Housing Act 1996, and the issue is whether that phrase is limited to physical violence and threats of physical violence as found by the Court of Appeal, or whether it can include psychological abuse, which could itself include matters such as emotional abuse or indeed financial abuse. If I can just start with a brief outline of our case and make three propositions. Firstly, it is in my submission absolutely clear consensus, there is an absolutely clear consensus that now exists that domestic violence includes both physical and psychological abuse. And I'll take your lordships briefly through the very wide range of courts and institutions which have adopted such a definition. So in my submission, following the approach of the Court of Appeal in this matter, would put the meaning of domestic violence in section 177 at odds with every other current definition. Secondly, the Housing Act 1996, and in particular section 177, has a clear statutory purpose to protect victims of domestic violence. And to give domestic violence a narrow definition, as the Court of Appeal did, fails to meet that statutory purpose. And the reason for that is the reason why all the current definitions include psychological violence. It's that such violence or abuse can cause as much harm to the victim, and indeed often the victim's children, as can physical abuse.
Is harm going to be the criterion that you're going to come on to?
Well, my lord, in terms of the statutory purpose, which is to protect victims of domestic violence, in my submission it is relevant to look at the nature of domestic violence and the harm that it causes to see whether that statutory purpose is met by the narrow definition. And I'll come to some of the material on this later, but I don't think the respondent really disagrees that, well, I know the respondent doesn't disagree because I'll show your lordships their own guidance on the matter, that psychological abuse can cause as much, if not more harm, in many cases, as physical abuse. It can ultimately drive the victim, and of course, usually the victim is a woman, drive the woman to suicide. It can cause serious and lasting psychological damage, and it can cause extremely serious damage to the children in a family concerned. And the third proposition is that there is nothing in the language of the statute, either section 177 or the wider statutory provisions, which force the court to adopt a narrow definition which is so plainly contrary to the mischief of the statute.
In addressing us on that chapter, you're going to look at subsection 3, are you?
I'm going to look at subsection 3. What I'm going to do, my lords, is start by looking quite briefly at the various definitions and the bodies that have adopted those definitions, then go through the statute in some detail, or the relevant provisions, and deal with what is in essence my learned friends' arguments, which are really about very tight statutory definitions. So turning then to the very broad and unanimous consensus as to what domestic violence covers. The sources are set out at considerable length in the cases, particularly the statements of case by the two interveners. So I'm only going to take your lordships through them briefly, but in my submission it is worth looking at them because one gets a sense both of the unanimity and the breadth of bodies that have adopted the definition. And the order I take...
You say we start by discussing what domestic violence means outside the statute before we look at what the statute says.
Well, my lord, that was what I was going to do in order to make good the proposition.
Well, I don't think I would have any difficulty in knowing that domestic violence is very widely interpreted outside. The question, I think, is whether that's the meaning in this statute. Isn't that right?
Well, my lord, obviously I have to show that the general meaning is now the meaning in the statute. But, and I'm happy to simply take it that your lordships accept not just that the general meaning now includes psychological abuse, but also that that general meaning has been adopted by the Court of Appeal, the European Court, the Family Division, the United Nations, and the government in numerous documents. So I'm happy to take that as read.
But you're saying we start from there before we look at the statute.
Yes, my lord, I do, because I say the statute has a purpose. The mischief of the statute is quite clear. It's to protect victims of domestic violence. If the court adopts a definition of domestic violence which excludes a large part of the reality of domestic violence, then the court is going flatly contrary to the purpose of the statute.
I think from my point of view, I'd quite like to know what these other materials are telling us as to why the expanded meaning is given and as to what the test is that should be applied. Because one of the problems that is raised against you is that if you move, if you move away from physical violence, which is, it is said, relatively easy to determine, you're moving into an area which is much more subjective and therefore much more difficult for the authority to form a view about. And I'd like to see just how this is sharpened up so that there's a test, a recognisable and useful test if you're going to go down that road.
Yes, my lord, I'm happy to do that. I think your lordship's question falls really into two parts.
It does.
Is there a clear test that can be adopted? And why should that test be adopted? Now, perhaps surprisingly, in some ways, the clearest statement of why it should be adopted is in the respondent's own guidance, which is a very nice short summary of why psychological and emotional abuse matters so much. So can I take your lordships? I wouldn't suggest that Hounslow Council was the most important of the many bodies, but it is a clear statement. If I take your lordships to volume 9, divider 103, which is very close to the end of the authorities. This is Hounslow's own guidance on what domestic violence is. And if one goes to the introduction, domestic violence, and I should say this document is dated to March 2009, domestic violence can come in many forms. It is any incident of threatening behaviour, violence or abuse, psychological, physical, sexual, financial or emotional, between adults who are or have been intimate partners or family members. And there's a reference back to the Home Office. And then the reason I take you to this is the next paragraph. It's rarely a one-off incident, and it is not only about being physically or sexually abused. You may be subject to more subtle attacks, such as constant breaking of trust, isolation, psychological games, and harassment. Emotional abuse is just as serious and damaging. Many survivors will carry the emotional scars long after the physical injuries have healed. And then on the opposite page, under emotional abuse is not as obvious as physical abuse, but it can be just as harmful. It can include humiliation, constant criticism, verbal abuse and name-calling, being put down in front of others, being kept away from family and friends, threats against you or others you are close to. And then it goes on to talk about destruction of belongings, excessive jealousy and possessiveness, control over what you wear and how you look. And then harassment can include being watched, being followed, being pestered, unwanted phone calls, letters, and being threatened. And then there's more about other forms of abuse, including financial abuse. But that's the section under the introduction and the section under emotional abuse is, in my submission, a nice, clear statement of why psychological abuse matters so much.
Yes,
and indeed, I will leave this to Mr. Knafler, has a great deal of material on the nature of psychological abuse. But one of the points that comes out of that material is that actually there may be a shifting in behaviour as society becomes stronger on stopping physical abuse. There may be a shifting of behaviour towards more psychological abuse within domestic violence. And that there's evidence to suggest that that is a phenomenon that's taking place.
The pages are not numbered, Miss Lehman, but it's interesting to see, just turning on about 2 or 3 pages, there's a thing that says, what happens to me if it's not safe to go back home, against the background that you've just been talking about. And it says, we will work with you to find a safe option. We will not ask you to return home or ask you to find somewhere to stay by yourself. I mean, that's related to the use to what happens in the home.
Absolutely, my lord.
This is, well, it isn't, there isn't a page number. It's before the page facing the one that's headed "Stopping the Violence," which is about 4 pages into the document, and it's in the bottom left-hand page. It's just, we will not ask you to return home. Just strikes me as.
You do accept, Mr. Eve and Mr. Darwell's point that this can be catered to under 1753?
Well, my lord, yes, but the answer to Mr. Drabble point was made by my Lady Justice Hale, as she then was, in a case called Bond against Leicester, which is that I'll take your lordship through the statute in a moment, but the point of section 177 is that it gives a special level of protection to victims of domestic violence. It deems them not to be reasonable to return home.
Right.
And also, it takes out the provision of section 177(2), which is when the local authority decides whether it's reasonable to continue to occupy, they can take into account the general housing conditions in the area. If you are the victim of domestic violence, that is irrelevant. So a critical part of the statutory scheme is that victims of domestic violence have the protection of 177. Mr. Drabble's argument is absolutely no answer, because it deprives victims of domestic violence, where the domestic violence is psychological abuse, of the statutory protection that Parliament intended to give them. It still allows them to rely on the general provision of 175(3), but that gives a general discretion, or not discretion is the wrong word, general judgment to the local housing authority about whether it is reasonable to continue to occupy, as opposed to the much clearer and much stronger protection to victims of domestic violence. So in my submission, if the court is going to accept that domestic violence includes psychological abuse, then it is robbing the Housing Act of the parliamentary scheme to then exclude victims of domestic violence whose abuse is psychological from the protection of 177. Now, I'll make that good in more detail in a moment when I go through the statute, but in my submission, Mr.
I'm sorry.
I'm so sorry, my lord, yes.
The document you've just shown us is a clear statement of why it's very important, but at the moment I don't feel it begins to be a clear statement of what behaviour we're looking at. You see, you used the word psychological abuse, you've used emotional, and I think you used once financial and financial. I mean, psychological and emotional are looking at what it does to, in the typical case, the woman. It leaves it wide open as to what it is that the man does. I mean, if we are going to restate the law, we do have to do it with some degree of precision, don't we?
Yes, absolutely, my lord.
You're going to tell us what we should say.
I am, my lord. I was going to deal with that at the end, but I think
Well,
given,
I think it's terribly important.
given your lordship's concern, I'll deal with it at the beginning.
You are being plunged, are you not, Miss Leven, right into every bit of your case
Yes,
by these
That's
questions.
that's what we're talking
Yes.
about.
That's fine, my
what
lady. That's
actually
the point of me being here. So.
Could I just suggest, but with great diffidence, that there's quite a helpful quotation in paragraph 62 of Women's Aid Federation's case. And the reason for drawing your attention to that is, firstly, it is a definition which is discussed in a Law Commission report that was published in 1992, in other words, before 1996, the title of the report being Domestic Violence and Occupation of the Family Home, and it talks about a narrower and a wider definition and gives some fairly precise indications about what the wider definition might encompass. That's just a thought, because I've been looking at the bits that were before 1996.
Yes.
My recollection, because I was around studying this area before 1996, was that there was plenty of people were adopting a not limited to physical contact and threats of physical contact definition way before then.
Absolutely, my lady. And if we can turn to the second intervener's case, because at page 24, paragraph 62, because the report I was going to refer to in the context of before 1996 was the Home Affairs Select Committee, so Parliamentary Select Committee, which is quoted at paragraph 61 of the intervener's case. I refer to it in my case via the Court of Appeal judgment in AN, Pakistan, but one comes back to these same reports. And what the Home Affairs Select Committee said in 1993 was one of our witnesses defines domestic violence as including any form of physical, sexual or emotional abuse which takes place within the context of a close relationship. Now, if I can just move from there to try to deal with one of my Lord Walker's points. The precision of the definition. Now, it is right, and I would accept that in the vast gamut of reports before your lordships and the court decisions, slightly different definitions have been taken. There isn't one absolutely clear definition. And one can effectively choose which source you want to rely on. Is it the European Court? Is it the Law Commission in 1992? Is it the Home Affairs Committee in 1993, as adopted by the Court of Appeal in AN, Pakistan? But the starting point is that every one of them include emotional or psychological abuse. Now, effectively, Mr. Drabble makes the point at the end of his case, there's no one clear definition. Well, at this stage, I, to some degree, fall on the mercy of the court, because in my submission, it is this court can set out one clear definition. But there is one absolutely clear theme through all these definitions, which is that it is not, domestic violence is not limited to physical violence, and it includes psychological abuse. Now, within psychological abuse, some of these authorities have broken it down into emotional abuse, financial abuse, sexual abuse, harassment. Some of them, such as the Home Affairs Select Committee, have simply stopped at physical, sexual or emotional abuse. Now, in my submission, it's for this court to adopt one of those definitions, and it perhaps doesn't matter whether one adopts a very extended descriptive definition or leaves it to a short definition with a judgment by the housing officer as to whether the behaviour that is being referred to by the victim falls within emotional or psychological abuse. So, for example, financial abuse may be such as to amount to psychological or emotional abuse. So that's...
You're not leaving the Law Commission definition, are you, which Lady Hale referred to? Because there is an interesting point, which I'm picking up from the top of page 25 in this intervener's case. Second line draws attention to the effect on the victim. And then the point which I think you've already made, actually, that such forms of abuse may be in some circumstances just as harmful, vicious and distressing as physical injury. So that was being appreciated in 1992 and in 1993.
Absolutely, my lord, yes.
And if one regards as violence as something which is to be determined by the effect on the person who is being, as it were, attacked by whatever means, you're saying one shouldn't be too concerned about the nature of it, so long as the effect is of a particular kind. Is that the sort of way?
That was the next. I'd broken my Lord Walker's question down into two parts, and the next part was how subjective a test is this, and does it all depend on what the victim feels?
Well, what do you mean by subjective here? Because I mean, you can determine a psychological injury by simply a study of the victim. A doctor can determine.
Absolutely, my lord. That was one of the points I was going to make. In the case of Danesh, I mean, to some degree I'm jumping around here, but I'm trying to deal with the substance of your lordship's concerns. In the case of Danesh, one of Lord Justice Newburger's concerns, as he then was that allowing violence to mean something wider than physical violence made it a completely subjective test. And if one goes back to Danesh, and I'll take your lordships to it a little later, you'll see that in Danesh that was the issue. But we in this case are not arguing for a purely subjective test. It is for the housing officer to determine whether the behaviour that is being reported to him or her is such as to amount to psychological abuse. And that is not just dependent on whether the victim says, I felt abused. It involves a professional judgment. And as my Lord Hopes just pointed out, such judgments can be made on objective bases with the assistance of evidence. And indeed, I would go further than that. In dealing with this argument that I'm seeking to create an unworkable test that will make housing officers' lives impossible, first of all, the kind of judgments that have to be made here about what was the nature of the conduct and does it amount to psychological abuse are the kind of judgments that housing officers have to make all the time, and indeed other professionals in this kind of context. They have to make judgments about, was the person intentionally homeless? Why did they undertake the actions they did? Is the property suitable for them, given their mental state and their nature of their vulnerability? And critically, and in my submission, this is the complete answer to this point. My learned friend, Mr. Drabble, says, well, you don't need to worry about psychological abuse as part of domestic violence in section 177(1) because you take it into account under section 175. But if you can take it into account under section 175, then the housing officer has to go through that exercise in any event. They have to consider, was the psychological abuse such that it is not reasonable for the woman to continue to occupy? So if they have to do the exercise under section 175, I do ask rhetorically, why shouldn't they be able to do it under section 177? So in my submission, the answer to the practical difficulties point is the exercise is no different from the type of judgments that housing officers have to exercise all the time. And secondly, if, as the respondent accepts, that judgment would have to be made under section 175, then it self-evidently can't be impossibly difficult for them to do it under section 177.
I mean, the 1753 test would be highly subjective. It would be, what is the effect of this on this particular woman? Is it intolerable, except for whatever the phrase is, that she should be required, so to speak, as a condition of getting homeless entirely, to go on living where she is? But I mean, if you're looking at 177, I mean, you're trying to find, aren't you, some very, very clear test as to whether this is deemed to be, and you don't look any further.
Well, my lord, That's right. But the housing officer actually has to address effectively a very similar question. Is the psychological abuse such as amount to domestic violence? That's the question under 177.1. And the question under 175 will be, in my judgment, is the psychological abuse such as to make it unreasonable for the victim to continue to occupy? So in both cases, the housing officer is going to have to address the question, what's the nature of the psychological abuse? Can I believe the woman? What's the effect on her of that abuse? And then it's right to say under 175 that the officer will then have to go on and think, in the light of that, is it reasonable for her to continue to occupy? Whereas under 177, he won't. But the first stage, which is what's the nature of the psychological abuse and what's the impact on the woman, will be the same under both sections.
Even supposing that I am obsessed with the woman who has gone, but she has, for whatever reason, she no longer wants to have anything to do with me. But I keep on phoning up and so on, and maybe calling and so on, which are the kinds of examples which one finds in the Law Commission, one of the examples. I may be doing it because I can't, in a way, help myself, and I'm devoted to her, so the last thing I want to do is to harm her, but that's what I'm doing. Is that psychological abuse, or do I have to have an intention to harm?
No, well, my lord, the point is that harm, with respect to your lordship, you're taking a physical assumption about harm. The harm to the woman from the ringing her up and pestering her and harassing her can be very severe.
I'm assuming all that.
You don't have to intend to harm.
You don't?
No. In my submission, intentionality is not part of the test.
Right.
Clearly, if it's physical violence, then subject to the drunken rampage where you're not in a state to have intentionality at all, and I'm not a good enough criminal lawyer to know if that could exist, physical violence is likely to have an intention to harm. But in terms of psychological violence, in the vast majority of cases, there will be an intention to harm. And your lordship may have picked up from Mr. Nafler's case that Women's Aid focus on the fact that much of this behaviour is with the intention of controlling the woman. But in my submission, it is not necessary for domestic violence to investigate the intention of the perpetrator.
Why not? I mean, there must be a reason for that proposition. What is it?
Well, because, my lord, the protection given to victims of domestic violence is about the impact that the domestic violence has on them and very often, in the context of the Housing Act, their children. The fact that the perpetrator may, as my Lord Rogers suggested, may have no conscious desire to harm, it isn't in my submission what the statute is about. The statute is about protecting the victim rather than investigating why they're a victim or what the perpetrator is seeking to do, although very often the two will go together.
One could perhaps think, well, positing a situation in which there is conduct which is having a harmful effect upon partner or children, or both, such that it is not reasonable to expect them to continue to live together. If the victim is accepted as homeless, she gets to leave the home and be looked after elsewhere. If the victim is not accepted as homeless, she'll have to go to the county court and get an injunction, and the perpetrator will be excluded, potentially. The family court will not be looking much at the intention of the perpetrator as opposed to at the effect upon the victim and the children, because they do a balance of harm test. That's what that's what the Part 4 of the Family Law Act is all about. So, in a sense, Neither is seeking to punish the perpetrator. That will be for the criminal courts to do. They're seeking to find a practical way out of the impossible situation. But the homelessness one is not, on the face of it, depriving the perpetrator of anything, except the company of his beloved, which is why he's behaving in this way.
Although my understanding is that in many cases, if the victim and the children move out, there may then be possession action against the perpetrator.
There may indeed. Well, that's another
that's
part of the forest. Yes.
Yes. Yeah. But in my submission, it comes back to the point that Section 177 of the Housing Act is there to protect the victim and potentially the victim's children. And in undertaking that protection, the question as to why the perpetrator is doing it isn't, in the vast majority of cases, relevant.
Can I just ask, just take a concrete example. A woman comes along to the housing officer and says, now look here, my husband, he keeps putting me down in front of others. Indeed, here's a tape recording. He's saying you can never find the way in the car. You always leave it until the shops are closed before you, etc., etc. What's the next thing that the housing officer has to do? Does he say, oh, well, this is a clear case of emotional abuse, psychological abuse, domestic violence, end of story? What does he do?
What the housing officer has to do is investigate those incidents in the same way that he would physical violence incidents. How often it's happened, give me as precise details as you can, have there been any witnesses, that kind of standard investigation.
She's got tape recordings and it's twice a week.
Then he has to ask himself, does it reach a minimum level of severity, those are the words of the Court of Appeal in AN, to amount to psychological abuse? Now, of course, we can, all of those of us who are married can know that you can have those kind of incidents on occasion, and you wouldn't dream of calling them psychological abuse. The housing officer has to use his or her professional judgment in the same way that he would about other questions of is it reasonable to continue to occupy, to decide, is this behaviour just the kind of disagreements that happen in so many relationships, or does it amount to does it reach a level of severity that I take the view is psychological abuse? The reality of this situation, as your Lordship asks me about the reality, is that if I succeed in this court and your Lordships produce a definition along the lines of either the Law Commission or the Home Affairs Committee, then in all probability the Secretary of State will then issue guidance as to the kinds of behaviour that housing officers should consider. But I'm very happy to accept, as was accepted in AN Pakistan, that the behaviour would have to reach a minimum level of severity. Otherwise,
judged by its results, psychological harm or an immediate risk of psychological harm. So, it must be looking at the effect on the woman.
It must be looking at the effect on the woman.
That's much more a question for a psychiatrist than a housing officer, isn't it?
Well, my lord, it may be. Clearly, this is an area where medical evidence may be highly relevant, as it is in physical abuse. But equally, the housing officer may be able to look at a course of conduct, may be able to look at the state of the woman in question, and be able to see that this is quite clearly a victim of psychological abuse. So there may be cases where there's psychiatric evidence, there may be cases where, for example, there's evidence from the GP of a long period of depression, of the woman reporting various incidents of what could be described as psychological abuse, perhaps of medication for depression, perhaps of suicide attempts, as was the case in a number of the cases. There may be medical evidence, there may not.
I suppose you could get into this sort of difficulty with physical violence. The woman presents with various injuries. The husband says it's nothing to do with me. It's self-inflicted.
Absolutely.
She does it to herself. And, well, there may be reasons why she does that, but a doctor would have to say, or could say, that these injuries are not the sort of thing you could inflict on yourself. These are the product of somebody else's violence. And this happens with battering children, doesn't it?
Yes. But also, my lord, there will be, it's well known that in many cases of physical abuse, physical violence, the woman may be very unwilling to report it. She may not have gone to the doctor, she may not have gone to the police, and she may come to the housing officer and say, I've suffered 5 years of physical abuse, but I've got no objective evidence of it. Perhaps not in the cases of really severe broken limbs or concussion, but in the case of slaps, bruises and so on, the woman may have no third-party objective evidence of the course of conduct at all. But the housing officer has to address the question of whether he believes the woman and the nature of the abuse. Because even in the case of physical violence, there will be cases where the physical violence is minor, is one-off, is not part of a course of conduct, and the officer takes the view that it doesn't reach the minimum severity. So I quite accept that in the case of psychological violence, it may be more difficult for the housing officer. I think it would be unrealistic not to accept that, because in some cases of physical violence, there will be objective evidence. There will be medical reports of bruises or broken limbs or whatever. But I do not accept that the level of difficulty for a housing officer is one that is unreasonable or out of the norm of the kind of things that such officers have to consider. And I also submit very strongly, and this is going right to the end of what were going to be my submissions, that given the level of harm from psychological abuse within the domestic context, the fact that we might be making it, your lordships might be making it a bit more difficult for housing officers and giving them a slightly more difficult task can't possibly outweigh the level of harm from this form of domestic violence, which otherwise falls significantly unprotected under the Housing Act. I'll come back to the statute in a moment. But if one's doing a balance, yes, I accept it might make it a bit more difficult for the housing officer, but if you look at the benefits for the woman, that's clearly outweighed.
Are we discussing here the meaning of domestic violence, or are we discussing the meaning of violence in this thing? Because, as you know, this section now includes or other violence, which definitely includes violence from third parties. Now, whoever that might be, the next door neighbour who is tormenting the woman might equally be causing her. It might really be the problem. Now, in that situation, would you not, on your argument, be applying the same test to that violence?
My lord.
And if not, why not?
Can I come to that in a moment when I go through the statute?
Well, if you give me the answer,
I'll
wait for the explanation.
The answer is in the alternative, my lord. My first submission is that actually violence can mean, outside the context of domestic violence, it can include abusive conduct. In my submission, it does not follow that violence alone has to be physical violence.
And giving that answer, you're not, the kind of conduct you're talking about isn't a threat of violence, is it?
It's not a threat of violence.
So this is something which falls short of being a threat of violence. It's something where violence of the physical kind is not being contemplated or suggested, but nevertheless it's abusive.
Nevertheless it's abusive, my lord.
Right.
And it's sufficiently abusive as to amount to violence. But if your lordships, I'll try and give this in a summary, if your lordships aren't with me on that and take the view that violence alone does not include psychological abuse, in my submission, the statute does not stop one interpreting the phrase domestic violence as a separate concept, clearly envisaged as such by Parliament. And it is not necessary under the statute to give violence the same meaning, the same restrictive meaning as in domestic violence. So in my submission, the easiest example to see, perhaps just for me, is the couple where one of the partners is severely disabled, is incapable of physical violence. And any threat of physical violence wouldn't be a genuine threat at all, but is deeply abusive of his or her partner. Psychologically abusive, undermining, verbally abusive, take the most extreme, drives that partner to suicide or to attempted suicide. No question of physical violence because that person is incapable of it.
I think you get some help. I'm sorry to interrupt you, but just to follow up Lord Rogers' question, if we look back at paragraph 24 of the intervener's case and the quotation from the Law Commission report, it says in the second sentence, violence is often used in two senses. You've got the narrower meaning, and then it says, but in the context of the family, it has the wider meaning. So,
24 of which intervener?
I think it's 62, paragraph 62, my lord, page 24, in the second intervener's case.
Yes, I'm sorry. It's this, but it's just that the Law Commission seemed to have picked up the point that if you're talking about the family context, in other words, the domestic context, the term is used to include what perhaps in the street might not be included.
Yes, my lord, it makes no difference to me, for the purposes of what I'm seeking to achieve, whether your lordships restrict this to domestic violence as opposed to violence as a whole. That's all I need for this case. And it is important in the forensic context to remember that Danesh, which was the case that led the Court of Appeal in this case to dismiss the appeal, Danesh was not a domestic violence case. And although the Court of Appeal in Yemshaw did know that, they don't appear to have focused on that fact. So when Lord Justice Neuberger in Danesh talks about the natural meaning of violence, he wasn't addressing domestic violence. And he wasn't taken to any of the definitions of domestic violence because it wasn't relevant to his case. Danesh was about racial abuse, not in the domestic context at all. But so, my lord, I'm quite happy to focus on domestic violence may have a particular meaning and is universally considered to include psychological violence. But to come back to my Lord Rogers' question, I will look at that in the context of the statute in a moment. My lords, I'm not going to say very much at all about the facts of this case, because in my submission that they don't really, the arguments don't really turn on the facts. Safe to say that if your lordships, and I'm not asking your lordships to do it now, but if you look at the original decision, or indeed the review decisions by the respondent, your lordships will see that this is a fairly classic case of psychological abuse, because Mrs. Yemshaw never said that her husband had physically harmed her and strongly suggested that he was unlikely to do so because, as she says, he was afraid of being prosecuted. But there's very clear evidence that she was frightened of him and that this was having a seriously upsetting effect on the children.
Sorry, frightened not of physical harm, but of what?
Well, my lord, that's the point I was going to come to. To be frightened of one's partner, particularly in the domestic context, doesn't mean you have to be frightened of them hitting you or throwing them down the stairs. You can be frightened of the violence of their language, of their psychological abuse, of their controlling behaviour, of their non-violent aggression towards you. All that can be deeply frightening. You don't have to be afraid that your partner's going to hit you to be very, very scared of them, particularly if one thinks of the domestic context. And for children, the fact that they've never seen their mother being hit doesn't mean that their father's behaviour isn't incredibly frightening for them. And in my submission, one just has to get away from this idea that the only kind of fear is fear of actually being hit or battered. In the domestic context, particularly, where one's talking about intimate relationships in a literally small physical space, being with a psychologically violent, aggressive partner can, in my submission, be just as frightening as being with a partner who is likely to hit you.
Is it because of the fear that this conduct will be continued?
Well, yes, there's no doubt at all that recurrence is a very important point. And in Bond, Lady Justice Hale, Lady Hale referred to the fact that usually domestic violence has this element of repetition in it. But it's difficult to get this point across without sounding very...
At all. I mean, it seems to be absolutely self-evident. I mean, I can't see how anyone could possibly dispute that.
No, my lord, in my submission, that's right. But what your lordships only have to think of being in a small room with somebody shouting very loudly at you. You may not think they're going to hit you, but it's still a deeply unpleasant experience.
Possibly undermining your whole well-being, it seems to me, obviously.
The difficulty with a case like this, my lord, is that what may seem very obvious to one of us may not seem so to others. So that's why I make the point so strongly. But in my submission, that kind of psychological abuse can be just as frightening and just as harmful as physical abuse. So, my lords, I'm not going to say any more about the facts unless the court wishes me to do so. What I'm going to do now is turn to the statutes and the statutory history, because both sides may make something out of the statutory history, so it may be important for your lordships to just see it briefly. If your lordships could take up volume 1 of the authorities bundle. And I don't intend to take long on the earlier statutes, but just to show your lordships how the principles developed. Divider 1 is the Housing Homeless Persons Act 1977.
This is the first time homelessness came in.
That's right, my lord. That was the introduction of the homelessness provisions into the statutory regime. And your lordships can see at section 1, subsection 2, a person is also homeless for the purposes of this act if he has accommodation, but B, it is probable that occupation of it will lead to violence from some other person residing in it, or to threats of violence from some other person residing in it, and likely to carry out the threats. So that was 1977. Then the next statute is the Housing Act 1985, which in this context was merely consolidating. So I don't think we need to spend any time on that. And
Which
then
one is it as a matter of interest?
tab 2, my lord. I'm just
2,
going through the tabs. I'm so sorry.
Yeah.
And then tab 3 is the Housing and Planning Act 1986, section 14, which introduced into section 58 of the main act, subsection 2A. And some of your lordships may remember the reason for this was to reverse the effect of the House of Lords decision in Pulhofer, so that a person was only treated as having accommodation if it was accommodation that it would be reasonable for him to continue to occupy, because Pulhofer had said that reasonableness could not be implied into the statutory test. So that's the Housing and Planning Act 86. And then we come to the Housing Act 1996, which is where domestic violence is introduced. Now, Divider 4 is the 1996 Act as originally enacted. Divider 5... I'm so sorry.
Yeah.
So, Divider 4, Section 177, as originally enacted. But I would suggest that in order to take your ladyship through this, I'm going to use the version at Divider 5 because that's got the whole of Section 7 in it, and one can see the amendments quite clearly in square brackets. So Divider 5 is the 1996 Act as it currently stands. And Section 175 is the core provision on homelessness. Person is homeless if he has no accommodation available. And then, for current purposes, the important provision is section 175.3. A person shall not be treated as having accommodation unless it is accommodation which it would be reasonable for him to continue to occupy. So that's the provision that Mr. Drabble relies on to say, oh, well, if the woman is subject or there is a victim of domestic violence, which amounts only to psychological abuse, then that person can rely on 175(3).
So when did that come in?
My Lord, that provision effectively mimics the 1986 post-Pulhofer amendment at Division 3.
Yes, so it's 1986, section 14, is it?
Yes, well, it was actually section 58(2)(a),
sorry,
introduced by section 14 of
Right.
the Housing and Planning Act 1986.
Yeah.
But that's what I would call the post-Pulhofer amendment.
Yeah.
And that then comes out again in section 175(3).
Yes.
And then the new thing in the 1996 Act is section 177. 177(1), it is not reasonable for a person to continue to occupy accommodation if it is probable that this will lead to domestic violence. That's the original version, and then or other violence is introduced in 2002. So for present purposes, I've just asked the court to ignore the or other violence. Against him or against a person who normally resides with him, any other person who could reasonably be expected to reside with him. And then in order to see, just compare the original version with the amended version, if your lordships turn back to divider 4, keep the two open, you can see in the original version of 177, the words were, rather than 1A, for this purpose, domestic violence in relation to a person means violence from a person with whom he is associated or threats of violence from such a person which are likely to be carried out. And then when we come to the 2002 amendments, that's been slightly changed to encompass the other violence, and I will return to that point in a moment. But just looking at the structure of 177 as it was enacted, we then come to 177(2). In determining whether it would be or would have been reasonable for a person to continue to occupy accommodation, regard may be had to the general circumstances prevailing in relation to housing in the district of the local housing authority to whom he has applied for accommodation or for assistance in obtaining accommodation. And then 177(3), the Secretary of State may by order specify other circumstances in which it's to be regarded as reasonable or not reasonable for a person to continue to occupy accommodation. And B, other matters to be taken into account or disregarded in determining whether it would be or would have been reasonable for a person to continue to occupy accommodation. Now, before I deal with the subsection 3 point, can I just...
Just pausing there, there is a difference between A and B, isn't there?
There is, my lord.
Because
Yes.
he's got, as it were, both sides of the equation in A. He can say what is to be regarded as reasonable and what is not reasonable. Not reasonable picks up subsection 1.
Yes.
Whereas you don't have the same formula in B. Other matters, I think I'm right in reading this as being all on the what would be regarded as reasonable. Is that right?
I think that's right, my lord, although I'm not sure that in practice that makes any difference, because presumably in defining what's reasonable, he could what should be taken into account in deciding what's reasonable, he might be said to be able to implicitly indicate what's not reasonable. I'm not sure, I haven't really thought about it, I'm not sure how much would actually turn on that distinction.
Yeah.
But, my lord, just going back to 177(1) and 2, in my submission, this section does two things for victims of domestic violence. First of all, in subsection 1, it's a deeming provision that if the continued occupation will probably lead to domestic violence, then it is not reasonable and cannot be reasonable for the person to continue to occupy for the purposes of section 175. So, deeming provision, Domestic violence, that's the end of it as far as reasonableness to occupy. Of course, the person still has to be in priority need. They don't necessarily get housed because of that, but it passports them through 175. But the other very important aspect of 177 is 177.2, because again, that's part of the post-Pulhofer compromise. In cases of where the local housing authority does have to consider whether it's reasonable to continue to occupy, they can take into account the general housing circumstances in the area. And your lordships will be well aware from other cases that in homelessness cases that will be a very important consideration, because in many housing authorities in England and Wales there is a severe shortage of public housing. And in deciding whether it's, for example, reasonable for a 5-person family to continue occupying a 3-bedroom flat, the local housing authority can take into account the general housing circumstances, or where you have a case of dilapidations, for example. So in practical terms, the ability of the housing authority to rely on 177.2 will be very, very important. But the effect of 177.1 is that for victims of domestic violence, because they're passported through the reasonable to continue to occupy, 177.2 doesn't apply. So there are 2 major benefits to falling within 177.1 as a victim of domestic violence. Benefits is the wrong way to put it. 2 major aspects to the protection. One, you're deemed not to be reasonable to continue to occupy, and secondly, 177.2 doesn't apply.
Well, they're the same thing.
They are, my lord, but they
Same
have...
point.
Yes, they're the same things, but they have different aspects. And in terms of the purpose of those provisions, I would ask your lordships to look briefly at the case of Bond and Leicester City Council. If you could keep the statute open. That's a case of the Court of Appeal. It's in Volume 2, Divider 19. Judgment of the Court of Appeal. My Lady Justice Hale gave the leading judgment, I think the only judgment. And the paragraph I'd like to refer your lordships to at this point is paragraph 5. I should say the issue in Bond was slightly different. The issue was whether or not a local authority could take into account other remedies which were open to a victim of domestic violence in order to decide whether 177.1 was met. In other words, whether it was probable that domestic violence would result. And but for these purposes, paragraph 5, it's common ground between Mr. Luber for the appellant and Mr. Arden for the respondent that section 177.1 applies a different test of reasonableness in domestic violence cases from that which applies in other cases. In other cases, the question of whether or not it is reasonable for a person to continue to occupy accommodation which is available to him is at large. The authority may take any relevant circumstances into account. Under section 177.2, regard may be had to the general circumstances prevailing in relation to housing in the district of the local housing authority to whom he has applied for accommodation or for assistance in obtaining accommodation. As Mr. Arden put it, people are not expected to put up with domestic violence because there is a housing shortage in the area. In domestic violence cases, the authority must apply the probability test in 177.1 and cannot take other matters into account. I only refer your lordships to that because it supports the submission I just made. While we're on Bond, so that I don't have to go back to it, can I ask your lordships also to look at paragraph 29, a few pages further on. This is where my lady refers to the repetitive element of domestic violence.
So it held otherwise than what?
Paragraph 29.
I know, but
yes.
held otherwise than what?
This goes back to the other remedies point, my lords. If your lordship looks at paragraph 28, underneath the quotation in paragraph 27 is the easiest place to pick it up. Clearly, therefore, the Secretary of State considers that there should be no pressure to explore alternative remedies, and the matter should be left open to the applicant. A later draft of the consultation of the code went further and omitted the words "if she feels it would be ineffective," thus reinforcing the view that the mere availability of such remedies does not answer the probability question. And then my lady says, I don't find this conclusion at all surprising. Effectively, it's left as issues of fact in the particular case. And then to hold otherwise would leave it open to local authorities to put pressure on the victims of domestic violence, which fail to take account of some of its well-known features. Once begun, it is likely to be repeated, often with escalating severity. It induces a sense of shame and of powerlessness in the victims, who often blame themselves and find it impossible to escape. There are various legal and practical remedies available, but it is by no means easy for many victims to invoke these.
So, I mean, this had explored what alternative possibilities, sort of injunctions and
Injunctions, my lord.
As I recall it, I mean, the argument was, well, it's not probable that you will suffer in the future because you could always go and get an injunction to stop it.
Absolutely.
Or to get him out. As I recall, the answer was, well, that's a question of fact as to whether it's probable. It's not a question of allowing the local authority to have a policy of saying, go and get an injunction rather than
Indeed, my lady.
accepting you as homeless.
But I mean, I'm sorry, can I just be clear then, did it leave it open as a possibility that in fact, you could go and get injunctions that would work and that they would do this? Or?
The question was whether it was probable that you would.
Yes.
Well, the question is whether it's probable that staying there will lead to domestic violence.
I see.
And encompassed in that, if it is probable that the woman will decide she wants to stay and therefore will take legal action to protect herself and her children, that's okay.
Yeah.
But expecting her to do it as a condition of being accepted, that was what the case was about.
And paragraph 31 is helpful, I think, if you look at that over the page, and particularly see how it ends up.
Yes, my lord, on that point, absolutely. And also, my lord, to answer a point that was made to me earlier, paragraph 35, where my lady is talking about the particular facts of Bond. If you pick it up at the top of the last page, there had been domestic violence in these very premises, it appears, when he was reluctant to leave after visiting the family. Obviously, he is the father, husband. Thereafter, although he had not forced his way into the premises, he'd taken to sitting in the back garden, shouting and throwing stones at the windows. This pattern of behaviour is all too familiar to family judges. Many victims find it a great deal more frightening than the violence itself. Now, in the context of Bond, that behaviour could have been taken as a threat of physical violence because there was a past history of physical violence. But it does show the pattern of that kind of behaviour can itself be very frightening.
I see it described in 31 as the clear rule.
Yeah.
Yes.
The rule is clear, what it covers is not so clear.
Yes. The clear rule is what Mr. Drabble calls the deeming provision, and I'm happy to adopt that. It's what I call the passporting through of the reasonableness to occupy.
Passporting is a better term than deeming, I think.
I'm glad your lordship says that. I shall remember that with Mr. Drabble in the future. So, my lords, in my submission, just going back to the statute, section 177, I've already made this point, but if I can just reiterate it now, we have the statute in front of us. In my submission, 177, 1 and 2, and the analysis that it passports through and relieves the relevance of 177, 2, is the answer to my learned friend Mr. Drabble's argument that you don't need to have a wider definition of domestic violence because the victim is protected by 175.3. Although it's right to say that she could be or might be protected by 175.3, it leaves the judgment as to reasonableness to occupy at large for the local authority, that's the phrase used in Bond, and it leaves the judgment open to the use of 177.2. And in my submission, that approach of Mr. Drabble's clearly deprives the statute of the parliamentary intent to protect victims of domestic violence?
Well, that's the question.
Well, my lord, it is. Well,
It is the question.
it is the question in a forensic sense, my lord. But if your lordships are with me, that domestic violence quite obviously includes psychological abuse. And in my submission, there's really no sensible counter-argument, and Mr. Drabble doesn't advance one. Once your lordships accept that domestic violence includes psychological abuse, then his construction does deprive the section of its parliamentary intent, of its mischief, because it leaves that victim of psychological abuse without the protection that Parliament intended her to have. And however difficult that may be, whatever the complications, that's what Parliament intended, once one accepts psychological abuse is part of domestic violence. And as I say, that doesn't seem to be seriously contested.
Well, I'm quite interested in whether Parliament also intended, and this is, because I think this is really, to me, it's an important question. Did Parliament also intend, and I don't mean to suggest the answer is no, did Parliament also intend that if she is living next door, for example, to some man which every time she comes home he shouts racial abuse at her, did Parliament intend in that situation that she should or should not be passported?
Well, my lord,
exactly the same awful undermining conduct, but it just happens to be the man next door.
My lord, in my submission, once one accepts, as in my submission one should, that violence can include psychological violence, then yes, Parliament did intend that. But what I would accept is, firstly, that's not the facts of this case, and I don't need that argument. But secondly, and perhaps more importantly, it's not as clear in my submission. I'm happy to accept that violence includes psychological abuse, because we don't have all the authorities that say it does. We don't have the Home Affairs Select Committee in 93 themselves accepting the definition of domestic violence, and the Law Commission report that my lady's referred to and is referred to in the papers. So I accept that is not as clear.
So if you go back to 1977, all you've got is the word violence.
Indeed.
Is that right?
Yes.
And then we see the history of the things, say the committee and Law Commission and so on, and then you get, if I've got my history right, the 1996 Act, which introduces the phrase domestic violence. And one has to wonder, well, why was that included if in 1977 it was thought enough just to use the word violence?
No, 1977 used domestic violence.
Used
as
domestic.
well.
Oh, it did, I beg
Yes,
your
it
pardon.
did. So Section 5.
Yes.
Ah, I'm so sorry.
5(1)(a)(3).
Yes, so that takes away that point.
And of course, one has
Yes.
to remember that the 1977 Act came very shortly after the 1976 Act, which was giving remedies, family law remedies for domestic violence.
Was it in 77A3?
And
Section 5(1)(a).
it's necessary to see, the trouble with most lawyers is they work in silos.
Right, yes.
But these things were going hand in hand. The development of family law remedies in situations of domestic violence, which was helped by the 1976 Act, which followed on from reports from the Home Affairs Committee in 1974 and 75, which may or may not have some useful material in them as to what was encompassed by domestic violence. Even then, I haven't looked them up, and I don't know that they're in either of the interveners' cases. You haven't gone back that far, have you?
I think that's right, my lady. When I ran through the list, I think the documents go back to the early 90s, and that's when the UN reports are, which
Yes.
I completely bow to your ladyship's experience, but I suspect maybe
No, age, Miss Even, that's what it is.
but may have fed into the Law Commission report. But I certainly am not familiar with documents that go back to the 1970s.
Well, the 77 Act doesn't say domestic violence, but of course that's what it means because
It
it...
does say.
It's
It
section,
says domestic violence in section 5(1)(a)(3).
Oh, right.
it's
Yes, it
11,
does that,
subsection
yes.
11A, is that
Yeah.
the...
Five, yeah, five,
We better look at this
Yes.
then.
five,
I mean,
page
It certainly escaped
1111.
me, and you didn't show us
No, I
that.
didn't, my lord.
Five,
We really ought to
A,
notice
little
that.
3,
So it's 5(1)A
A, little 3.
little
right,
3
it does.
with 11, subsection
Yes,
11.
With what?
Subsection 11, which gives a little more meaning to domestic violence.
So it's the same.
It's the
kind of
referral.
Yes, it is. Threats.
Yes, I see. The risk of threats of violence. I mean, a threat of violence likely to be carried out perhaps implies, does it not, that you really are looking at what is intended by the perpetrator.
Certainly, my lord, when you're dealing with threats of violence, where I think all the way through the statute has this test of whether they're likely to be carried out, then yes, you must there be looking at what the perpetrator intends. But threats of violence is more likely to arise in the context of physical violence than psychological violence. Because I'm quite happy to accept that it is difficult to envisage a threat of psychological violence which doesn't itself amount to psychological violence, if that doesn't sound too circular. Because if you're threatening it, then the very threat will be psychological abuse. Perhaps wrongly, but the way I've focused on this is to ask two questions in terms of the statutory construction. First of all, what did Parliament intend in 1996 when Section 177 was enacted? And secondly, if your lordships don't accept that domestic violence in 1996 encompassed psychological abuse, would it do so now? And is it appropriate to apply an always speaking living instrument approach to the construction of this statute? So that's why I focused on 1996 onwards.
Well, then, on this approach, oughtn't we to be looking at 1977?
It's rather curious, the structure of the 77 Act, because you've got the formula put out fairly clearly, I would have thought, in subsection 2 of section 1, which you referred us to. But then we've got it all put in a sort of negative way in section 5, isn't it? That it's not subject to the duty if neither the person who applied or any other person would run the risk of domestic violence. It comes in there, and subsection 1, and also in subsection 4B.
Section 5 is about referring to a different local
It is.
authority.
It's the side note, yes, tells
Yes.
us what it's about.
That's right.
And
Yes, why it's
The
used.
point of section 5, as I understand it, is mirrored now by section, I think it's
198.
198.
Yeah.
And the effect is that local housing authorities should not refer on to another housing authority if in the area of that other housing authority the person is likely to be subject to the risk of domestic violence. That's section 198 2C in the 96 Act.
And we get the same formula actually now in section 198 of the 1996 Act with an amended section 2A, which seems to match what we saw in section 177.
That's right, my lord.
So the amendments carry through to that chapter as well. And
Those
so
provisions carry across. The slight oddness, and I can't, I'm afraid, explain it, those behind Mr Morici may be able to do so, is why in 1977 the referral duty referred to domestic violence, but the primary duty didn't expressly.
right.
I'm afraid I don't
Yes,
know
it
the
is.
answer to that.
well spotted.
I think the person in the room who's most likely to know the answer is my Lady Hale.
No, I don't at all.
So having admitted I can't answer that question, can I take your lordships back to the 96?
Sorry, I'm terribly sorry.
I'm so
I
sorry,
mean,
Lord.
I suppose you are right, are you, in saying that the 77 Act, the main part doesn't apply to it? I mean, I'm just looking at section 1(2)(b). I mean, this is some other person residing in the accommodation.
I'm so sorry, my lord. I didn't say didn't apply, I said didn't refer. The slight anomaly is that the main section, section 1(2), doesn't actually describe that conduct
I
as
see.
domestic violence. That concept is only introduced in section 5.
Well, Section 5 has got a slightly more complicated concept because it covers also a separated partner who might come beating on the window, the sort of Bond case, which isn't covered by Section 1, subsection 2, I think.
Yes, that's entirely, that doesn't seem to be right, my
So you
lord.
find that in
So the
Section-
parliamentary draftsman at that stage said, this is getting a bit complicated, let's have a definition of domestic violence.
Which subsection are we looking at? Is it in section 5?
Section 5, subsection 11.
Yes.
I assume, but I have to admit I'm only guessing, that the reason for that is that where you're talking about referring to another housing authority, then the victim and the perpetrator are already not living together. And the danger, the mischief in section 5(1)(a)(3) will be sending the victim to a place, to an area where the perpetrator of domestic violence lives. I guess that's what is going on here. Or that may have been what was assumed. So there's no doubt, to answer my Lord Brown's point, that the 1977 Act, Section 2, was considering what we call domestic violence, but it didn't label it as such in that subsection.
Yes. Well, where do we go now?
Well, where we go now, my lord, is back to section 177 of the 1996 Act, because there are a few points of statutory construction in there which I need to deal with. As far as, first of all, section 177(3), which your lordships will remember, both Lord Justice Newburger in Danish and Lord Justice Etherton in the present case, relied on section 177(3) effectively to say, well, the Secretary of State can get round this problem by using his order-making power in 177(3)(a) to designate, for example, psychological abuse or psychological abuse in domestic violence. My Lord, I'm going to leave the statutory scheme on that and the reasons for non-designation to Mr. Morici, because it's really his clients and his client's point. So I think I know he has an answer, but I think it would be more appropriate if it came from him, and then your lordships and your ladyship can ask him whether it's a good answer or a bad answer. In my submission, it's a good answer, but I'll wait for that. But the submission I make on this is the very simple one, that the fact the Secretary of State can specify circumstances cannot possibly, in my submission, change the definition of domestic violence in 1771. With great respect to the Court of Appeal, in my submission, the argument that because the Secretary of State can do something else, that changes the core definition, cannot be right. The next statutory construction point, it is to deal with the threats of violence argument. Now, the reason I do this is that the Court of Appeal in Danish, and Danish is at volume 2, divider 22, your lordships will remember Lord Justice Newburger gave 5 reasons for rejecting the argument in Danish, and they start at paragraph 15 of the judgment. And the second reason was about threats of violence. What His Lordship said there was, secondly, in section 198(3), and Your Lordships can see that's up for the transfer power provision. Violence means A, violence from another person, or B, threats of violence from another person. Lord Justice Newberger said, violence is defined as A, violence, or B, threats of violence which are likely to be carried out. It seems to me that if Mr. Loveland's contention is correct and the judge was right, the sort of actions which are said to be encapsulated within paragraph A really render paragraph B redundant. It's a little difficult to see how violence extends to the full concept of assault in criminal law if it was necessary to include the extension in paragraph B. Indeed, paragraph B, involving as it does a purely objective criteria, seems positively inconsistent with the judge's view. Now, my lords, in my submission, it's important to understand that paragraph in the context of the arguments being advanced in Danish, because what was being advanced, as I've already said, it wasn't a case about domestic violence. And what was being advanced was that the kind of abuse that Mr. Danesh was suffering amounted to violence. And one can see that at paragraph 13 above. On the first point, the meaning of the word violence, it is said on behalf of Mr. Danesh that Mr. McDougall directed himself in the review letter into thinking that violence required physical assault or physical contact of some sort, whereas at any rate, in the context of a case such as this, involving violence to the person, it includes words, actions or gestures which cause the applicant to fear physical attack. So what I would suggest was a rather difficult argument was being run in Danesh, which is that behaviour which the decision maker had decided was not sufficient to be a threat of physical violence within section 1983B could amount nevertheless to violence in circumstances where what was being argued was that it led Mr. Danesh to fear physical attack. So it was trying very hard. It wasn't being alleged that it was psychological abuse freestanding, or indeed it wasn't in the context of domestic violence. And the
so
argument...
what was said to have happened?
My lord, you can pick it up. I think the best way well, if you go to paragraph 8,
No.
that's a quotation from the review letter, third line down, between E and F. In December 2003, you told Miss Edge that you'd been experiencing problems with some young people on the Townhill estate where you lived. You told Miss Edge that these youths made trouble late at night near your house and at a nearby shop. You also told Miss Edge that you're often shouted at when you wait for a bus. Further, a man on a bus would not let you sit next to him and used strong racist language. On the 23rd of March, you reported problems with youths shouting and flicking their middle finger at you. You told Miss Edge that someone at the bus stop asked you if you were Al-Qaeda. There were also 2 more serious incidents which occurred in January and June 2004. You fell and hit your face. The perpetrator had gone. Now, the argument in Danesh, which one can pick up in paragraph 11, internal paragraph 27, that this is the judgment of the judge below. I think looked at as a whole, the reviewer did not lay sufficient stress on the perceptions of the victim in this case. That is to say, Mr. Danesh and his wife, on the probability of this happening again, of the same type, if they were to return to Swansea. And what one can see from paragraph 19 of the judgment is that counsel for Mr. Danesh was arguing for a purely subjective test. Fifthly, Mr. Loveland accepts that if his definition of violence is correct, an applicant will be entitled to have a subjective test applied to the question of whether or not he feared violence. So that was the argument being put in Danesh. And one can see in that context that the kinds of threats in question, it was difficult to, or the kinds of language in question, it was difficult to see why, if they weren't threats of violence, which the original decision maker had found that they weren't, how they could then fall within the statutory definition.
I mean, does your submission come to saying violence means A, violence, physical or psychological, from another person, or B, threats of violence meaning physical violence from another person?
Well, I don't need those last words, or threats of violence.
No, but you accept that actually that only makes any sense in the context of physical violence.
Yes, my lord, yes. So I would say that violence means physical or psychological violence, yes, and threats of violence, but I accept that threats of psychological violence are unlikely themselves to amount to a separate category.
But what if the abuse takes the form of locking somebody in the house without actually having to push them anywhere and depriving them of food? This is a not uncommon situation.
Yeah.
Yeah. Surely a threat of that's not physical contact violence. That is psychological abuse of the strongest sort. Surely to threaten to do it again would be covered on your case.
Oh, absolutely, my lady. The only reason I look slightly doubtful is that I think it would be quite possible to find that the threat of that conduct alone was itself psychological abuse.
It would be, yes.
It's not the threat of psychological abuse, it's the actual abuse itself.
You could. I see what you mean, but it's...
Yes. But
One
certainly
can get a
such
bit
behaviour
precious
would
about
be
these
covered
things.
in my submission, beyond any doubt. The example I would give of threats comes back to my example of the severely disabled partner, where the threats, there might be threats of physical violence, but they couldn't possibly be carried out. And the partner objectively would know that, but they could still be threats which amounted to psychological abuse. Whether you call them threats of psychological abuse or actual psychological abuse perhaps doesn't in this context matter very much. Then just returning to the statute, so your lordship see the structure, because there's one other section which is relevant, and I'm conscious of the time. The other section is section 182, which is, section 178 is the list of persons associated. And it is perhaps relevant to note that it's a very wide list, and it doesn't just include partners. So it's right to point out that domestic violence could be, for example, violence from a grown-up child who's living with you. And then section 182, guidance by the Secretary of State. This is the statutory power to issue guidance, and also the statutory duty on local housing authorities to have regard to such guidance. And that's important in my submission in the weight to be attached to the guidance. And then your lordships have already seen section 198, which is the referral power. I'm not going to take your lordships through the more general provisions in part 7 on the assumption that your lordships are reasonably familiar with them. Now, the only other statutory thing I should point your lordships to is the next divider is the Homelessness Act 2002, and that is the act that introduced or other violence into the 1996 Act. And that leads me to another statutory construction point, which is both taken against me and taken in my favour by Mr. Morici, which is does the addition of the words or other violence suggest that Parliament did think that psychological violence was covered or not?
Sorry, I'm being a little bit slow. That's the one that inserted the three words in 1771.
The three words in 1771, the new version of 177, well, 1771A, capital A, and made comparable amendments to section 198 by reference to 2 capital A. And it introduced other violence as also passporting through. And, my Lord, this is really, again, Mr Marici's point, and he'll make more of it, make further submissions on it if your Lordships feel it's useful. But in my submission, if one looks at 1771 as amended, it does suggest that Parliament thought that domestic violence was a freestanding or separate concept from other violence. Because if it was simply intended that all violence would be covered, then it wouldn't have been necessary to keep domestic violence at all. Because if other violence covered everything, then all that Parliament needed to do in 2002 was just say, lead to violence. So the fact that Parliament said domestic violence or other violence does, in my submission, suggest that Parliament saw domestic violence as a separate issue or concept.
I see. I mean, the point you're taking is that they didn't strike out domestic, they added or other. Is that the point?
That's right.
I see.
If they thought domestic violence was just a form of violence with no other elements, then you don't need it as a separate concept any longer.
You'd have to strike out a bit more.
Well, you would. You'd have to then make consequential amendments.
Yes, but I mean, the subsection 1A, you say, wouldn't be necessary on what you've just been saying. Is that the point?
Well, you certainly wouldn't need the bit about and violence is domestic violence if it's from a person who is associated with the victim. If my reading of the statute, and as I say, Mr Marici make further submissions on this, is that if in 2002 Parliament had just intended all violence to be treated exactly the same, domestic or otherwise, then you wouldn't have needed to have any reference to domestic violence in the 1996 Act at all, because all violence would just have been encompassed together.
And it wouldn't matter who was the perpetrator.
Exactly. Exactly. So the fact that the amendment is made in this way is, in my submission, an indicator that domestic violence is a separate concept, potentially with its own slightly different definition, not just in terms of person associated, because you don't need that, but also in terms of what might be covered by it.
So is one capital A brought in at the same time in 2002?
Yes, my lord, you can see that.
Well, I mean,
Divider 6,
Yes, it's in the 2002 Act.
Section 10, introduces 1A, but your lordship can see that something close to 1A existed in the original version of 177. If you go back to Divider 4.
Yes.
Divider 4, 177 still has the definition of domestic violence. The fallout words of 1771.
It is very interesting that section 178, with its complicated definition of associated person, is still there. What's it trying to tell us?
Well, my lady, in my submission, what it seems to be trying to tell us is that domestic violence may be treated as a freestanding concept. And therefore, I quite accept that reduces the force of the submission that violence on its own and violence in domestic violence means the same thing. And it may support the submission that psychological abuse might fall within the definition of domestic violence, but not general violence.
It's a little bit tricky. I mean, I take your point, of course, entirely, but I mean, the way 1A runs is, it first of all tells you what violence means. And then it says, and violence, which is what they've just been describing, violence is domestic violence if it is from a person associated with the victim. So the primary concept is violence, and it's only then a particular form of that concept is described as domestic violence. So it doesn't. I take the argument, but it doesn't run quite.
I agree.
Quite so easily.
With respect, my lord, I entirely agree. It's not that the parliamentary draftsman does not appear to be entirely clear on the point. It's not the first time that may have happened. That has happened. And I accept that those words at the end of 1A do linguistically suggest that violence is the same in both. But if that's right, then all the provisions about domestic violence independently become OTOs.
I thought I'd be the last person ever to ask this because I don't approve of looking at green papers and so on if one can avoid it. But is there any indication as to what Parliament actually intended by extending it, in this case in 19 whatever it is, to other violence? In other words, do we know whether Parliament thought that it was a different kind of violence and you were going to have to put up with racial abuse from your next door neighbours, but not from your partner?
My lord, I'm not conscious of anything that assists on that.
Lord Steyn always used to ask when points of that were raised, what about the notes on clauses? Is there anything that you know about?
We do know what the 2002 code says.
My lord, let me just check.
I think that information.
Yeah, yes, but that's... My lord, I would have to admit, I don't know the answer. I don't know whether Mr Naffler, who's conducted this very extensive search, found anything on 2002. He tells me they couldn't find anything of any assistance. That doesn't mean it doesn't exist, but I'm afraid
So can I be clear? I mean, this business of other violence comes in both with regard to the primary position, 177, but it also comes in, doesn't it, in 2002, for the first time, violence at the hands of, complete strangers, in 198
yes.
in 2002.
The Section 177 amendments are, as I said a few minutes ago, mirrored in Section 198 for the referral provisions. My understanding, probably from nothing more than reading the newspapers, is the 2002 amendments what were to deal with general abuse, for example, racial abuse, violence within council housing, outside domestic violence. But I am not conscious of anything that helps in 2002 on the relationship between domestic violence and other violence.
Yes.
The 2002 introduced protection against third-party violence, if we can just call it that.
In the non-domestic context.
In both contexts, for all purposes, to do with homelessness for the first time. Is that right?
Yeah. It introduced the passporting provision. Of course, if you were a victim of violence, say you lived on a council estate and you were being constantly harassed by your next door neighbour or their children, then you could always, ever since 1977, have argued that it was not reasonable for you to continue to
What
occupy.
is now 1753? Exactly.
1753, yes.
Quite, but for the passporting provision and for the not being sent back whence you came, for both those provisions, first time comes in 2002?
Expressly, my lord, yes.
Well, you say expressly.
Well, no, the reason I say expressly is that I would have assumed, although I'd have to find the provision, that in 198, 198(2)A. No, sorry, that's not right. I would have expected that somewhere in 198, one would find a similar provision for conditions of referral, that it had to be reasonable for the person to live in that area. I'm not going to be able to find it very quickly. Perhaps I can ask Hodgson to have a look.
Well, no, there may be an equivalent of 1753, but
the passporting element, yes.
the passporting and the express increase from risk of domestic violence if you're sent back to Swansea, which is 1982C, and then you bring in 2A to deal with non-domestic violence.
Yes, that's absolutely right, my lord.
Thank you.
But it's presumably sort of neighbourhood violence, isn't it?
Yeah.
Yes,
I think.
yes, absolutely.
Yes.
And which will often be in a racial context. One suspects that was in the mind of. But just finally on that point, my learned friend, Mr. Drabble, puts considerable weight on this or other violence and the fallout words at the end of 177 1A. But
Sorry, which?
the point that my Lord Rodriff made, that
I see,
violence is domestic
yes,
violence
I
if it's
see.
from a person who's associated with the victim. But, my lords, it simply cannot have been the case that the 2002 Act positively acted to restrict the definition of domestic violence. That would be completely illogical and contrary to all the documentary evidence as to the thinking about domestic violence. So to the degree to which, I may need to come back to this in reply, but to the degree to which it's being suggested that the amendments in the 2002 Act positively made this distinction.
So the definition of violence comes in 2002 for the first time?
Well, the concept of other violence as being expressly relevant comes in 2002 for the first time. That's the passporting point.
No, but then the definition of violence in 1 capital A, 1771 capital A,
Yes.
comes in for the first time and equivalently, as we know, in 189.
No, it was in 1771 in the original version of the 96 Act, if you look at tab 4.
Yes.
But my lord,
In a different
my lady,
formula.
in tab 4, the original version was
Yes.
simply a definition of domestic
That's right.
violence.
Yes.
It wasn't a freestanding definition of violence.
No, of course not.
Yeah.
But it was using the same things that are in 1A.
Yes.
And you had the same Section 178 list, of course.
Yes, and you had the same Section 178 list. My lord, I'm conscious of the fact that on
Yes.
our timetable I have exactly 7 minutes left. So can I just really summarise the rest of my submissions, because I think your lordships have the core of my case. But the one aspect I have not covered at all is the principle of statutory construction, as the statute being what's described in the cases as a living instrument. It is in my submission very important here, where your lordships are addressing the construction of this particular phrase, to have in mind that this is a statute with a specific social purpose, that is to make provision for homelessness, and in section 177 to provide protection for victims of domestic violence. And the fact that it is this statute or its predecessors is one with a particular social purpose. I refer to the case I referred to in the statement of case, Dinn and Wandsworth Council. I'm not going to go to it. Divided to Authority 23, where in respect of the 1977 Homeless Persons Act, Lord Wilberforce said that the Act should be interpreted with liberality, having regard to its social purposes. And I draw two things from that. First of all, if the court gives domestic violence a narrow construction, then it robs section 177 of an important part of that social purpose. But secondly, the fact that the Act has such purposes, in my submission, makes it entirely plain that it falls within that category of statutes where it is appropriate to take a living instrument or always speaking approach to construction. And that means, in my submission, that it isn't critical for your lordships to focus on what Parliament intended in 1976 or even in 1996. If your lordships are confident, and in my submission you can be, that domestic violence now includes psychological abuse, and that the mischief of the statute requires that interpretation to be adopted, then in my submission your lordships should take that construction. And I've referred in my case to the case of the Royal College of Nursing and the DA and the Department of Health and Social Security. The reference is Authorities Bundle 4, number 44, capital A. But the critical paragraph, I quote in the case at paragraph 24.
Yes. Is this Lord Wilberforce again?
This is Lord Wilberforce again, different case, but still Lord Wilberforce. And he refers to when a new state of affairs or a fresh set of facts bearing on policy comes into existence, the courts have to consider whether they fall within the parliamentary intention. They may be held to do so if they fall within the same genus of facts as those which the expressed policy has been formulated. They may also be held to do so if there can be detected a clear purpose in the legislation, which can only be fulfilled if the extension is made. And in my submission, that principle, that sentence applies precisely here.
Well, does it? I wonder if it does, really. I mean, because that sort of suggests that that this state of affairs didn't exist. I mean, what Lord Wilberforce is talking about is a situation where some new thing comes into existence, a new situation. But that's not what we've got here. I mean, it would have existed. People were being abused in these ways in 1977, I suspect in 1877. The question is whether or not Parliament actually intended to cover them. And I doubt very much whether this approach really applies.
Well, my Lord, I would put it in two ways. Either Parliament was cognizant in 1996, and indeed quite possibly in 1977, but we need focus only in 1996, of the fact that domestic violence included psychological abuse, and psychological abuse was just as harmful. So that's the Law Commission report, the Parliamentary Select Affairs Committee. In my submission, that's right. Parliament clearly intended in 96 that psychological abuse would be included.
You think of literature, it's filled with characters who are abusing their wives and so on and so forth.
Well,
everyone knows that. The question is, did Parliament intend that to be covered by the concept here?
And the answer to that, my Lord, is why on earth wouldn't have Parliament intended that? What possible reason, given the social purposes of the Act in 96, could there have been for Parliament to exclude psychological abuse? So that's my primary submission.
Yes, and you're not pointing to any change in human behaviour, are you?
I'm not pointing to a change in human behaviour. The only the change I'm pointing to, potentially, if the court... I don't rely on a change as my primary submission, but as my secondary submission, I do point to all the copious material, particularly produced by Mr. Knafler, which suggests that there has been an increased understanding of the role of psychological abuse in domestic violence. And that, in my submission, it's not a clear-cut change, as it was in the RCN case, where there was a change in medical knowledge, but it's a societal knowledge and acceptance that has increased incrementally, probably from the 1970s through to now, where there is a universal acceptance that psychological abuse is, including by the respondent, is part of domestic violence. So I start by agreeing with my Lord Roger, but if I don't carry the whole of the committee with me on that, then I have the alternative submission.
Could I just ask one thing? Because I accept entirely the point that Lord Roger has been making in relation to the Royal College of Nursing type development. What would you say about a case like Fitzpatrick and Stirling Housing Association, where one is talking about the definition of member of a family, where the legislation went back to the 1920s? And the idea that people living together outside marriage would have been regarded as members of the family in 1922 was unthinkable. But by the time we get to the 1999, people living in a same-sex relationship were regarded as members of the same family. Now that's the same word, not a change in behaviour, but a change in society's understanding of what the word means, which might or might not be relevant to this debate. I'm asking you.
In my submission, it's absolutely relevant, my lady. As I say in paragraph 25, although the RCN case was about medical knowledge, the principles of the RCN case were applied in Fitzpatrick to changing societal understanding of the word. My understanding was that Lord Rogers' question was slightly different, point was slightly different, which was that, well, actually in 1996, society was well aware of this. To which I would accept, yes, that would be my primary submission, but to the degree the court has any doubt as to whether Parliament was aware of it, there has been the growth in knowledge and understanding since 1996. And the clearest recognition of that, or the clearest recognition of the increased understanding of the problem, is in the two versions of the code. And I'm conscious that, despite the fact the Court of Appeal spent most of it...
It's neatly set out in your case, because you draw the comparison between the 2002 and 2006 codes.
So by 2006, absolutely clear, Secretary of State was saying psychological abuse is included. Couldn't be clearer. So, and that's evidence that although I'm sure my Lord Rogers' view is correct, many people in 96 did know about psychological abuse, particularly, well, not particularly, but definitely including anybody who sat in family courts in the United Kingdom. By 2006, we can see that clear understanding. And there are three codes to look at. I'm not going to go through them, but they're all in Volume 1. And can I just make one point about the 96 code and the 2002 code?
Yes.
The Court of Appeal in Danish relied on the 2002 code to say that violence only meant physical violence. But I would ask the court to note that, of course, Danish not being a domestic violence case, Lord Justice Neuberger didn't even look at the bits of the 2002 code about domestic violence. He was focusing on paragraph 832 in that code, which is actually about harassment. He wasn't thinking about domestic violence at all. And I would suggest, if your lordships go back to that code, and Mr. Marici may take you to it as he will have some more time, that actually the 1996 code and the 2002 code are silent as to what domestic violence covers. They don't, I would suggest they don't assist either way. They do not say that domestic violence is only physical violence. So, my lords, just finally, I think I've made all my submissions, albeit in a rather different order. Can I just come to this point about practical difficulties and make 6 points, some of which I've already covered. First of all, housing officers routinely have to consider matters that involve difficult and sensitive investigations, including considering the psychological state of the applicant for housing. Secondly, on Mr. Drabble's case, the same issues would have to be investigated in any event under section 175(3). Thirdly, we are not arguing for a subjective test, as was argued for in Danish.
Yes.
Fourthly, we accept that there must be a minimum level of severity for the behaviour to amount to domestic violence. And I refer your lordships to the case of AN Pakistan, which is at Authorities Bundle 2, number 17, paragraph 24. And whether that test is met is obviously a decision for the Housing Authority. Fifthly, in any event, even if it is more difficult for the housing officer to make a judgment about psychological violence, that cannot be a good reason to undermine the purpose of the statute. And sixthly, Mr. Drabble in his case says housing officers need a clear test. In my submission, it is open to this court to give a clear test. And all the different definitions. I don't want that submission to sound cheeky, but that to some degree is the purpose of taking a matter such as this to the highest court. And although it's right to say that various of the documents provide slightly different wordings of the test of what is domestic violence, that all the definitions, as the Court of Appeal said in AN, come down to something very similar, which covers physical, sexual or psychological abuse. I'm sorry the end of those submissions was so fast, but I'm very conscious of my place in the timetable.
Well, you've written an extremely clear case, and it may be your junior too has assisted in that.
Indeed.
Mr. Hodgson, do you wish to add anything? Thank you very much indeed. Yes, Mr. Marici.
My Lords, my Lady, I want to deal with 3 points. First of all, the section 177, subsection 3 point. That's the point that was raised in paragraph 30 of the judgment of Lord Justice Etherton below, to the effect that the court should be hesitant to apply an always speaking construction to the meaning of domestic violence in section 177 because the Secretary of State has the power in section 177.3 by order to specify other circumstances where it's to be regarded as reasonable or not reasonable for a person to continue to occupy. Then, secondly, to deal with what I say on behalf of the Secretary of State should be the meaning of domestic violence in this Act.
Yeah.
And then, thirdly, perhaps linked to that, what I say about the place of the Code in the construction arguments that are before this Court. So, can I deal with the section 177, subsection 3 point? I don't think we need to go to it, but as I've said, it's paragraph 30 of the judgment below, which is in Appendix Part 1, page 10, Roman numeral 5. I don't think we need to look at it, but it's also a point taken against me by Mr. Drabble.
Paragraph number again, sorry.
Sorry, my Lord, it's paragraph 30,
Yeah.
and it's in Appendix Part 1, it's page 10, Roman numeral 5. And for the Court's note, in Mr. Drabble's case, it's paragraph 18. He effectively sets out some of this paragraph and relies upon it. But the basic point, as I've already indicated, is effectively Lord Justice Etherton indicating that the Court should be hesitant to apply the always speaking construction because the Secretary of State has the power to make an order to specify other circumstances in section 177. Now, in response to that, I want to make these points. And first of all, I do adopt what Ms. Leaven said in relation to this. And perhaps I should also say that the Secretary of State adopts and supports all the submissions made by Ms. Leaven. But I adopted the submission that she made, particularly in relation to this. What she said was that whether there is a power or not to extend the circumstances in which it's reasonable or not reasonable to leave accommodation can't be decisive of what the phrase domestic violence means in the first place. So I adopt that point. But I want to make these additional points. First of all the parties before this Court are agreed that domestic violence... all the parties before the Court are agreed that domestic violence has the same meaning in section 177 and section 198, i.e. the reasonableness provision and the reasonableness passporting provision and the transfer between authorities provision. And just 2 references, I don't ask you to look at them, but Lord Justice Etherton recorded that as a matter of agreement in paragraph 11 of the judgment below, and it's a matter of agreement expressly recorded by Mr. Drabble in paragraph 15 of his case.
Paragraph what?
15 of Mr. Drabble's case and paragraph 11 of the judgment below. My Lords, can I then ask you to turn to section, with that in mind, ask you to turn to section 177, subsection 3, which is in volume 1, tab 5, page 675. The power in subsection 3 is the Secretary of State may by order specify other circumstances in which it's to be regarded as reasonable or not reasonable for a person to continue to occupy accommodation. So the first, perhaps obvious point I make is one has to be dealing with other circumstances. And what does other circumstances mean in this context? Well, in my submission, it must mean circumstances other than those dealt with by section 177, subsection 1. Because effectively, in my submission, what Section 177 subsection 3A does is it allows the Secretary of State to effectively extend the passporting provision to other circumstances.
Yes.
So in order for there to be vires to exercise this power, the starting point is the Secretary of State would have to accept that domestic violence in Section 177 sub 1 did not extend beyond actual physical violence. And if the Secretary of State started from that point, then he would be able to say, I will then deal with other circumstances, namely psychological, emotional abuse, etc., by making a deeming, by making a passporting provision through order. And my lady, I make this submission. And first of all, obviously you'll understand the Secretary of State does not accept that that is the narrow meaning of domestic violence.
So he regards himself at the moment as powerless, but if he loses, or he, or if the appellant loses the appeal, then everything's fine, he can do it.
Well, not everything's fine, but I mean, yes, in one sense, if we lose the appeal because this court says domestic violence is confined to actual physical violence, then I agree we could exercise the power in Section 177(3)(a, but there would still be a difficulty, and the difficulty is this. As I said at the beginning of this section, the definitions of domestic violence in Section 177 and in Section 198 are the same. Everybody agrees. No difference. This power to change things by order does not apply to Section 198. So whereas we would be able to extend the meaning of, effectively to extend the protection in Section 177 through a passporting provision, we would be confined to a narrow definition, the narrow definition which I'm assuming the court has adopted here, of actual physical violence in Section 198. So there would be a disparity and a break between the protections given to those who suffer from domestic violence in Section 177 and Section 198, and which your lordships have seen have kind of grown up together and have been amended together to form a sort of comprehensive part of a code of protection for those suffering domestic violence.
So there isn't any let out at all in Section 198, is there?
No, we don't believe there is. There's certainly nothing in Section 198. There are various powers in Section 198, you can see in subsection 6.
Yes.
But that's about an order for the arrangements for what happens if local authorities can't agree on transfer. And there is an order in place which effectively sets out the
in
kind of
default of
arbitration.
agreement. Yes. So you read 6 with 5.
Yes.
Yeah.
Well, so that wouldn't allow us to change, effectively to extend the protection through order in Section 198. And I haven't been able to find any other provisions in the Act.
I see, going back to the notes to section 177, that there is an order in place. Do you happen to know what that deals with?
There is an order, but that's an order made under Section 177(3)(b).
I was just wondering whether, for our education, you knew what
yes,
it was.
I do know what it is. It is, just give me one moment.
We've got it, have we?
No, it's not.
Something to do with 16 and 17-year-olds?
It's the suitability of accommodation order, and effectively, it's actually dealt with in the case of Bond. If I just look at Bond for one moment. Case of Bond, which
Bond is 19.
yes, tab 19. If you look at paragraph 6 in the Bond case. Sorry, it's...
So it seems to be something to do with affordability.
Yes, it's affordability. There's a whole series of provisions. And in fact, it's also dealt with, if I could just give your lordships the reference, in the Moran case, which I'll just find the reference for.
Well, I don't want to take out too much time. I mean, I think that answers the question.
So, obviously there isn't any exercise of the Section 177(3)(a) power as yet. There hasn't been any exercise of that power. Now, what I did also want to add on this, and just to draw the court's attention to, is if I could actually hand up something that's not in the bundle. It's further part of the 1996 Act. I've got some. I'll just pass those around. I haven't got a huge number. These are provisions from Part 5 of the 1996 Act. which are, as far as I can see, the only other parts of the 1996 Act which use the phrase domestic violence. And very briefly, you'll see on the first page of the handout, section 145 introduced a new ground 2A, the heading for section 145 being new ground of domestic violence. And effectively, it's a new ground of possession in relation to secure tenancies where there's been domestic violence. Similarly, section 147 introduced that in relation. Section 147 introduced the same in relation. Section 147 is, if your lordships go to go to page 3, you'll see there's again reference in the provisions for notice under here to in 3A. The ground, or one of the grounds specified in the notice under section 83, is ground 2A in Schedule 2, domestic violence. So simply that again.
Is there any equivalent of section 1773 in relation to these provisions in Part 5?
Not that I know of, but I'd have to double check. I will have to double check.
Well, perhaps you could. Yes, don't take up time just now, but it'd obviously be interesting to know.
I will check that. Yes, and then similarly on page 4, you'll see the very same ground effectively was introduced in relation to assured tenancies.
But I mean, is there any definition of domestic violence?
Well, there isn't any. There isn't beyond the effectively one can see. There's a definition which is really focused upon. For example, in 14A on page 4, it's simply focusing on the relationships rather than on the meaning of domestic violence per se.
Where am I looking on page 4?
If you look at page 4,
yes.
ground 14A, the definition of effectively of where possession can be sought is mostly focused on the relationships between the parties. But one sees at C, one partner has left the dwelling house because of violence or threats of violence by the other towards that partner or a member of the family.
So it's the same, pretty well the same as ground 2A in section 145.
It is. And so, again, the same point arises that if this court concludes there's a narrow meaning of domestic violence in section 177, it may be that that narrow meaning also feeds through into these provisions. And I'll check the point about whether there's an order making power. So I think that deals with the first point I wanted to deal with, which was the section 177 sub 3.
I mean, it's implicit, I suppose, in the whole scheme of the Act that you could get this discordance that you suggest would arise between the Secretary of State saying, well, it's a good idea to say you can't be expected to go on living here, you're entitled to be rehoused, and then, but nevertheless, disqualified from having regard to that when it comes to sending them back whence they came.
Well, it's true that by the order there could be additional circumstances which passported you through section 177. Exactly. But my lord, in my submission, that the difficulty that I've referred to, and which I say is important, is that if domestic violence is given a narrow meaning, because that's dealt with expressly in both of those statutory provisions, you have a breaking of the common meaning between those two provisions of the phrase domestic violence. It would have a wider meaning in section 177 than in section 198. Because, my lord, if I'm correct, then obviously one doesn't use the power in section 177 other than to deal with other circumstances. So you could be passporting people through for all kinds of different reasons, nothing to do with anything within the scope of domestic violence or abuse. But in my submission, the difficulty here is that if you can passport through, if domestic violence is narrow and one therefore passports through other forms of abuse, you have got this disparity between the two concepts. I mean, I accept that there isn't an order-making power in 198, so obviously there is that difference. But well, can I then deal with the other 2 points briefly that I wanted to deal with? One is what I say is the meaning of domestic violence in this context. And can I go to that by just taking your lordships briefly to the case of AN Pakistan, which is tab 17 in bundle 2. And well, it was a decision of the Court of Appeal. In the judgment of Lord Justice Richards, one sees at paragraph 2 that Lord Justice Richards sets out the relevant paragraph of the immigration rules, as they then were. And one can see in the first paragraph of the quote, they're dealing with the requirements to be met by a person who's the victim of domestic violence and who's seeking indefinite leave to remain in the United Kingdom. And one sees, if one goes to paragraph 17,
Read 2C.
2C, is able to produce such evidence as may be required.
So where are you now reading?
Sorry, Mr. Jabber wants me to read from the quotation in paragraph 2. He wants me to read C. It's one of the conditions in the immigration context is able to produce such evidence as may be required by the Secretary of State to establish that the relationship was caused to permanently break down before the end of that period as a result of domestic violence.
Yeah.
And then if one goes to paragraph 17, one sees in 17 the grounds of appeal summarised about 5 lines down. 1, the evidence before the tribunal showed that domestic violence had been perpetrated against the appellant and the tribunal erred in looking for actual physical violence. And then there's a heading on the same page, towards the bottom of the page, domestic violence. And paragraph 20 starts by saying the December 2009 version of the Immigration Directorate instructions gives a definition of domestic violence used by the Home Affairs Committee of the House of Commons in a report in 1993. Any form of physical, sexual or emotional abuse which takes place within the context of a close relationship. In such occasions, the relationship will be between partners or ex-partners. And then it refers to a more up-to-date version of a report. If we go over the page, it says it refers to a commonly adopted definition across the UK government, which is any instant of threatening behaviour, violence or abuse, psychological, physical, sexual, financial or emotional. And the court will realise that that is the definition which one also finds in the code in 2006. And then 22...
That's exactly the same as it is the 2006 code?
Well, I'll go to the 2006 code. The key part, which is violence or abuse, psychological, physical, sexual, financial or emotional, is identical, and I'll show you the code in a moment. And the reason is this is based on a common definition that you will have seen was adopted in 2005 in the National Report on Domestic Violence, and since then has been used across government.
Yes.
And one then sees in paragraph 22 reference to the Family Division's practice direction on residence and contact orders, which states that paragraph 2, the term includes, that's the term domestic violence, includes physical violence, threatening or intimidating behaviour, and any other form of abuse, which directly or indirectly may have caused harm to the other party or the child, or which may give rise to the risk of harm. And 23 is this, the general thrust of all these definitions is much the same. It's unnecessary for present purposes to choose one in preference to the others when considering the rules. And then 24, Mr. Mahmood accepted that for conduct to constitute domestic violence, it must reach some minimum level of seriousness. And that was a test Ms. Leven advocated, and which I also support, which will depend upon the context and particular circumstances. This is inherent, it seems to me, in the very concept of violence or abuse. And it's also consistent with the underlying policy, as indicated by the categories of domestic violence listed in the guidance. And it refers to various items. And it says AI Pakistan establishes an applicant is not limited to evidence within those categories. The definitions used by the UN and by the Family Division Practice Direction point in the same direction by the references to harm or the likelihood of harm or risk of harm. So the points are, if I can just make these 2 brief points on it. First of all, there is clearly this common definition across government, which one can see in the immigration context, but one sees it also in the code, which I'll come to in a moment. But secondly, one can see that immigration officers are already having to deal with the issue of domestic violence in that wider sense. And I would add this, the code, which I'll show you in one moment, has been in place since 2006, offering the wider definition of domestic violence, which I contend for and which the appellant contends for. And there's no evidence before this court that applying that test has been impossible or excessively difficult for housing officers.
Yes.
Could we then just look very briefly at the code itself, which one finds at tab 13 in volume 1.
2006 code, eh?
2006 code, yes, ma'am. And it's paragraph 8.21 at page 71. And paragraph 8.21, the Secretary of State considers the term violence, so this is violence more generally, first of all, should not be given a restrictive meaning. But then particularly goes on to domestic violence, and that domestic violence should be understood to include threatening behaviour, violence or abuse, psychological, physical, sexual, financial or emotional, between persons who are or have been intimate partners, family members, or members of the same household. So that is effectively the same definition that we saw was being applied in the immigration context. One also observes there that the Secretary of State is making the point that domestic violence has a particularly wide meaning. So deals with violence first, don't give that a restrictive meaning, but in particular, domestic violence has a wide meaning.
What does the Secretary of State mean by his first words then?
Well, my Lord, simply that really this chimes with submissions made by Miss Leaven, that even if one's focusing on the word violence, there is material which supports the view that violence outside even the domestic context can go beyond actual physical violence.
So what does it cover?
Well, my Lord, the argument in Danesh focused on the fact that for assault, under the law as it now is, one doesn't need to have physical contact. So it's simply making a point, and no more than a point, than simply that one shouldn't take a restrictive view of violence. In my submission, i.e., shouldn't restrict it to meaning necessarily just actual physical violence.
Or threat of physical violence.
Or threat of physical violence.
But you say it goes wider than that, so that the neighbour who is constantly being tiresome and harassing you psychologically, that's violent.
Well,
is that what the Secretary of State's saying? I mean, I'm just trying to see what he's saying.
Well, no, it's not saying, my Lord, what's the point that arises here is simply that domestic violence is intended to have a particularly wide meaning, i.e. there's a recognised wider meaning to domestic violence. It may be that violence also has a wider meaning than simple actual violence or threats of actual violence, but the view that's being expressed here is that domestic violence is particularly wide.
Why does the all-seeing Secretary of State not know what he means by violence?
Well, why is no more said? Well, my Lord, I mean, there is more guidance as one goes through dealing with issues of violence and threats of violence.
Not there, anyway.
Not in this
I can't
paragraph.
find it. I'm looking at paragraph 8.24, and he still distinguishes between the two.
Yes.
Perhaps he feels he's just stuck with the statutory language and doesn't want to expand it, but I don't know.
Well, my Lord, it does fit with the point, the construction point that which Ms Leaven made and which I made in my case, about the fact that Parliament, of course, did, when it made the changes in 2002, insert the words or other violence rather than deleting the word domestic, i.e. that Parliament, if one accepts that construction argument, seemed to think that there was some difference between violence and domestic violence in terms of their width.
Well, time's running
Yes,
rather
it
against
is.
you, I'm afraid.
Can I just reiterate the point that Ms Leaven made, that if one actually, I'm not going to have time to do this, but if one goes to the 2002 code, which was relied on in Danesh,
Yes.
the provisions on domestic violence, which were not the provisions which were referred to in the judgment, don't say anything about the scope of domestic violence. So they don't positively make the point that the 2006 code does, that it should be given a wide meaning, but nor in my submission is there anything there that suggests it should be given a limited meaning. So in effect, it was neutral on the issue of what the scope of domestic violence was. My Lords, I think the very final point, I'll do very briefly, is in terms of where the code fits in terms of the construction arguments. Really two short points. First of all, the code itself is, of course, further evidence of the wide acceptance of domestic violence as going beyond actual physical violence. It's just another example, but obviously an important one, because it's contained in the statutory guidance made under Section 182. The Secretary of State's submission is that obviously that document is merely persuasive as to the meaning. I don't put it any higher than that, and I accept the exposition of the law given by Lord Justice Morbick in the Brent case, which is set out in the judgment below by Lord Justice Etherton, i.e. it can be persuasive, but it obviously can't be decisive.
Yes.
Well, I think that's all. Given the time, I better stop. Thank you very much.
So we're very grateful for your assistance. Now, Mr. Naffler, I think looking at the timing, if you could try to complete by 15:15, but if you run over to 20 past, I think that wouldn't interrupt Mr. Drabble too much.
I shall do my very best, my lord. And the issue before the court is whether the expression domestic violence in section 177 of the Act includes in principle, for want of a better phrase, psychological abuse. And it may come as no surprise that the Women's Aid Federation of England agree with the appellant, and the Secretary of State that it does, and with their reasons. There is a slight difference of approach as to what amounts to domestic violence for these purposes. That's not a difference that will make any practical difference in the vast majority of cases, and I'll address that very, very shortly. But first of all, Women's Aid would wish to point to the materials set out in the cases in support of the appeal as demonstrating that in 1996, as now, both internationally and in this country, violence against women per se, and also domestic violence as a slightly separate concept, both had an established meaning outside of the 1996 Act, which included psychological abuse. I can give two examples of official documents that reflected that general understanding. The UN Convention on the Elimination of Violence Against Women, referred to as CEDAW, paragraph 15, dates from 1979 and defines violence against women and domestic violence as both including psychological abuse. And then the Law Commission report at para 62 of our case that Lady Hale has already drawn attention to, dates from 1992.
Well, was it appreciated in those days that men could be victims of psychological abuse as well?
In our understanding, yes, my lord. We submit that it was 1996 was not that many years ago. And we submit that in 1996 it was generally understood in a non-gender specific way that domestic violence included psychological abuse, so that there may be no need to use the always speaking principle. And also, like the Secretary of State and the appellant, Women's Aid submits first and foremost that on ordinary principles of statutory construction, there's nothing in section 177 strong enough to justify reading down the ordinary meaning of domestic violence as found outside the 1996 Act in ordinary speech and as something like a term of art. On the contrary, the purpose of section 177 was to clarify the protection available to women by using the expression domestic violence instead of violence as a qualifier, and by contrasting domestic violence with other violence when the 2002 amendments came in. But there are some points of detail that Women's Aid particularly wish to draw attention to. First, what is psychological abuse for these purposes?
Sorry, could you say that again?
First, what is psychological abuse for these purposes? And Women's Aid draw attention to the power and control wheel at tab 105 of the authorities bundle. It's an explanatory tool developed by the Domestic Abuse Intervention Project, an international. This is. I'm sorry. This is volume
7.
9.
Oh, sorry, 9.
I see.
It's an explanatory tool developed by the Domestic Abuse Intervention Project, an internationally respected project based in Duluth, Minnesota. And inside of the wheel, the Duluth project provides typical but not comprehensive examples of what conduct can amount to psychological abuse. Next, and perhaps more interestingly, what level of psychological abuse requires a housing officer to decide that there has been domestic violence? On this point, Women's Aid note the approach of the appellant and the Secretary of State that psychological abuse becomes domestic violence when it reaches a sufficient level of seriousness so that it can properly be described as violent or abusive, and that chimes with the approach of the Law Commission report to which my Lady Hale has drawn attention to, and there is obviously a great deal that can be said for that approach. However, and whilst recognising that it won't make any difference to the outcome in the vast majority of cases, Women's Aid adheres to its view that psychological abuse amounts to domestic violence when, in the light of all the circumstances, it involves controlling, coercive or bullying conduct. Women's Aid take the same approach to physical violence, and in that respect we follow the approach of the report of the Secretary-General to the UN General Assembly, which is set out, the relevant part of which is set out at paragraph 18 of our case, which indicates that domestic violence has a somewhat more specific quality than violence against women as defined in instruments that deal with both or more generally with violence against women.
Sorry, your definition we're going to find in paragraph 18, will you?
It reflects the approach of the report to the UN General Assembly at, which is set out at paragraph 18
Where do we find the
of our case.
power of wisdom?
They call it intimate partner violence, and it's dealt with specifically at paragraph 113 of that report. And you can see that the focus is on coercion, bullying and control in this specific context. I hasten to add that one can certainly find definitions of domestic violence in international materials and domestic materials which treat domestic violence in exactly the same way as violence against women more generally, and does not contain these qualifiers. But you see the qualifiers here, you see the qualifiers in a certain number of definitions, and the Women's Aid approach reflects that. Say, for example, and I'll just give an example, if one had a partner who had Alzheimer's and who lashed out in their predicament physically or verbally, that conduct may well cross a level of seriousness, but it will not necessarily amount to domestic violence on the approach of Women's Aid. It certainly might, because on having regard to all the circumstances, it might be that that partner was controlling, intentionally or not, coercing or bullying, but it might not.
So you are looking to the intention of the perpetrator then, are you?
Well,
As the criterion?
it's not the intent. All parties recognise, I think, that there needs to be some control mechanism to filter out what conduct, physical or psychological, does and doesn't amount to domestic violence.
Yes.
Our difference is very slight, and we certainly submit, as do the appellant and the Secretary of State, as I understand them, that there's no need to go as far as establishing the subjective intention of the perpetrator, whether the perpetrator is a man or a woman, and whether the relationship is heterosexual or homosexual. On our approach, there's domestic violence when, in the light of all the circumstances, the conduct is controlling, coercive or bullying.
Which paragraph gives us the clearest indication of your contended for definition?
What paragraph, my lord, of?
Your printed case?
I think it may be. Paragraph 3.
What your triple was controlling, coercive, what was the other one?
Or bullying.
Or bullying, thank you.
Is whether the conduct objectively is controlling, coercive or bullying in the light of all the circumstances. I mean, clearly the more one is able to ascertain about all the circumstances, including the subjective intentions of the perpetrator and the consequences on the victim and the whole history of their relationship, the more easy it will be to decide whether or not the conduct is controlling, coercive or bullying. But it's not necessary to know any of that information if A,
partner is locking the other partner up in the house, and that is all the information that one has, objectively one can conclude that that is controlling. It may be
definition
thought...
intended to be wider, is it?
I'm so sorry.
Your definition intended to be wider than the other.
Well, we think that it is slightly narrower,
Slightly
if anything.
narrower.
It is slightly narrower than the approach of the appellant.
I mean, it wouldn't cover, or would it cover a man who neglected his wife, kept her short of money, and was having an affair with another woman? Would that be controlling, coercive, or bullying? It could cause her considerable psychological harm.
Only knowing those facts, it would certainly be open to a housing officer to decide that it was not. But knowing more about the facts of the case, for example, about the intentions of the man and the effect on the woman in the light of their marital relationship,
Because
it may be
Miss
necessary.
Levin has rather disarmingly said it's up to us to decide, but we really do need a lot of help, I think,
Yes.
if we are to try and define this.
Well, Women's Aid thought long and hard about whether to simply adopt the same line as the appellant or to give the court a different option. And in the end, because this is their view, primarily, we have been asked to intervene, we thought to give the court the possibility of looking at it a slightly different way. Not that it will result in great practical differences. I mean, it's difficult to conceive of physical violence as ever not amounting to controlling, coercive, or at least bullying conduct. But sometimes it might not be. I've given the example of the Alzheimer's spouse. One could also think of a child or teenager with autism or a spouse with a serious mental illness. Those are not factors that will automatically mean that violence is not controlling, coercive, or abusive, but it may put a different complexion on violence. Equally with psychological abuse, it's hard to imagine any real difference between abuse that reaches a minimum level of seriousness and abuse that's controlling, coercive, or bullying, but there could be some small differences around the edges. For example, a decision to give a partner just an allowance to manage on wouldn't necessarily, in Women's Aid's approach, amount to domestic violence if it reflected a long-standing consensual approach within the marriage about how to arrange their affairs. But unilaterally imposing that sort of arrangement in the context of a long-standing agreement to share financial rights and responsibilities would be, because of its bullying, coercive and controlling nature.
The word controlling seems to appear time and time again in your case, and we find in the conclusion at page 33 and 34 that is the real thrust of what you're submitting. I think there's you got what you say is a clear ordinary meaning in paragraph 71, which is abuse which is aimed at controlling women, and then we've got controlling in paragraph 76. So this is that really is the key to your approach as I read it.
There may have been a certain emphasis on controlling, but Women's Aid are anxious to indicate that there is a spread, controlling, coercion and bullying. That may be quite a narrow spread, as your Lordship has.
This is footnote 2 to your paragraph 3.
Yes, indeed. Right. They may be asked why Women's Aid prefer a slightly narrower approach. Firstly, on the approach of Women's Aid, it is more apt to introduce these qualifiers, to actually explain what domestic violence is as a term of art, as Women's Aid understands it. And secondly, a sufficiently serious minimum level of violence is rather broad. It doesn't give housing officers much guidance as to what domestic violence is, and it does give them a great deal of leeway. Identifying whether conduct is controlling, coercive or bullying does afford a practical structure for decision-making that could help the decision-maker and also to some extent constrain the scope of the decision-maker's discretion in a reasonably appropriate way. because one's not looking here at questions of reasonableness, but as to questions of whether or not domestic violence has actually taken place.
The two propositions are not necessarily inconsistent, because you could apply the test of sufficient level of seriousness to physical violence as well as what was needed in order to attract the protection of Section 177.
I think that again raises one of the concerns of Women's Aid, that on their approach, Section 177 is intrinsically not concerned with levels of severity and doesn't operate in a way that gives housing officers a power to disregard certain levels of violence as being irrelevant because they don't meet a particular threshold. The way it operates, in my respectful submission, is to include all levels of domestic violence that include physical violence, providing they come within the definition. Once one goes down the minimum level of severity route, then one can get into some quite murky territory as to whether or not a push or a slap, for example, in relation to physical abuse, reaches that minimum level.
What about bullying behaviour of the man next door? What about him? Has Women's Aid got a view on that?
Yeah, well, yes. It's obviously not the primary focus of Women's Aid's considerations. But on our,
why is that not of interest?
why has it not been the primary?
It seems to me someone's life could be made absolute hell by what's going on there.
Absolutely. With the approach we take is that domestic violence is something of a term of art, and I've given the court our take on it. Violence against women, irrespective of domestic violence, also has an established meaning as including psychological abuse. So we would have no difficulty in seeing abuse from a next-door neighbour as falling within the bracket of violence against women. As far as concerns that level of violence, though, against women and that level of violence, psychological violence against men, on the facts of a particular case, it may be more difficult for an applicant to persuade a housing officer that what has taken place amounts to violence because of its psychological nature. And in that respect, one might need to look at the concept of a minimum level of severity. But that is not a concept on Women's Aid approach that really helps in relation to domestic violence. The next issue for Women's Aid is what is the connection between psychological violence and physical violence, and why is it so important to provide remedies addressing psychological violence? Based to some extent on the work of Dr. Evan Stark, which is at tab 104, who's a leading American academic, but also its own work and experience, Women's Aid have got a number of submissions wishes to put before the court on this issue. First, many men still do use serious physical violence causing serious physical injuries. See the statistics at tab 85. There is some...
Right, which tab? I thought you told us...
This is tab 85.
104 is Dr. Stark's paper.
104, I'm sorry, in volume
Volume
9 is Dr. Stark.
Sorry, is that what you want us to look at or something different?
Well, no, I just make the submissions. I'm just flagging up that the submissions are based to some extent on his work, which is at tab 104, but also on Women's Aid's own experience.
Yes,
in
he's
this
talking
field.
about coercive control. Is his
Yes,
theme, I think.
that is his theme.
Yes.
And there's some evidence that levels of serious physical violence have decreased globally in response to the energetic application of the criminal law and changing social attitudes. But in this country, unlike in America, there is no clear evidence of any sustained fall in serious physical violence in the UK. Although statistics do show falls from time to time in response to particular local initiatives. The next submission is that over the last 30, 40 years, there seems to have been a sharp increase in less serious violence like pushes, grabs, slaps, light punches, as well as in psychological violence. But whether those have been real increases, it's very difficult to say. There's a school of thought that they are real and are attributable to some men consciously or unconsciously reverting to less serious physical abuse and psychological abuse because of the lesser risk of prosecution and of social stigma. Women's Aid would suggest that there's some truth in that. But equally, there's a school of thought that these increases result from greater reporting, from a greater awareness that less serious violence and psychological violence are unacceptable, and Women's Aid inclined towards that particular view. But whatever the underlying reason, the consequences of psychological violence can be very serious. By definition, on the Women's Aid approach, the victim will have been subjected to controlling, coercive and bullying conduct, and is likely objectively to have been controlled, coerced, bullied, exploited, and very often, surprisingly, perhaps, virtually held hostage in their own home, which is what may have happened to Ms. Yemshaw. Equally, there are likely to be strong subjective feelings of fear, in particular, but also humiliation, shame, depression, self-loathing, and all of that impacts severely on children. Next, psychological abuse very often results in actual physical violence at some point. It very often has the implicit or else lying behind it, the or else of physical violence, if the psychological abuse isn't swallowed by the victim. But the underlying threat in our submission may not be of physical violence, but of becoming homeless, or penniless, or losing the children, or suffering in some other way because one partner is unequal in power or status to the other. The fundamental underlying condition in Women's Aid submission is fear, which can be created by a variety of means, but which traps the victim in the home and in the relationship. And then finally, as flagged up by Ms. Leven, it's impossible in Women's Aid submission to say that the consequences of physical violence, even the worst sort of physical violence, are worse than the consequences of psychological violence. Victims who experience both often say that the physical violence wasn't the worst part, that the psychological violence was more frightening at the time and more devastating in its consequences, and both have serious consequences for children. And the prevalence of that sort of abuse and the need to address it and provide vulnerable women with adequate protection are made clear in all the international material and all the domestic material. And that really brings one to the question of what is adequate protection. In paragraph 9 of our case, we refer to the Home Affairs Committee's third report, which says we are convinced that an adequate response to domestic violence will be impossible unless refuges and move-on housing are available for victims of domestic violence. So an escape from the psychological trap is essential, and my Lady Justice Hale's judgment in Bond is to similar effect at paragraph 68. Now, the problem with that, my lords, is that there are insufficient refuge places provided by Women's Aid and its affiliates to meet even the demand for emergency and very temporary shelter. And that lack is getting a great deal worse because, it will come as no surprise, at the present time, local authority and central government funding for Women's Aid organisations is reducing sharply because of austerity measures. So local authority move-on accommodation is critical if many women and children are not to remain trapped in homes where they may suffer serious irreversible damage because of psychological abuse. But the only legal submission I wish to make is, if I may, is in response to paragraph 23 of the local authorities case, which on its face makes a strong point, because what the local authority says, and this is in relation to the human rights argument, they say that there is no need to apply Section 3 of the 1998 Act. If the abuse is of a sort that will give rise to a breach of a convention right, it would plainly be wrong for a housing authority to hold that it was reasonable to expect the individual concerned to occupy the premises. Now, Women's Aid respectfully take issue with the word if. In our submission, it is always and in every case incompatible with a woman's right to respect for her life, or if one prefers it, her moral and psychological integrity in her private life, to subject her to psychological abuse of a controlling, coercive or bullying nature, or of a sufficiently serious degree on the appellant's approach. There has, of course, to be a factual inquiry and an exercise of judgment, but once that threshold is crossed, once it's established and accepted that a woman's partner has gone so far down the line that he's abusing her psychologically in order to bully, coerce or control her, that in every case, in my respectful submission, is plainly inconsistent conduct with Article 8. Take the appellant's circumstances. Her partner demanded she stay at home, cook for him, clean the home, and gave her no money to buy anything from the shops. Now, with respect to the appellant, this is not by any means the worst case of psychological abuse, but in the submission of Women's Aid, it very plainly indeed was a course of conduct that did not respect the appellant's life or her autonomy incompatibly with Article 8. Now, as I understand it, the local authority concedes in principle that where a perpetrator's conduct is incompatible with Article 8, then accommodation must be provided by the local authority. Now, if that's the case, that leads on not just to the consideration of principle that I've just alluded to, that in all cases of bullying, coercive, controlling conduct of this type, there is a lack of respect for the woman's private life. There's the pragmatic consideration. The local authority's understandable desire, which would be shared by everybody in this field, is for there to be a clear and workable scheme. Now, a scheme in which psychological violence, as we define it, or as the appellant defines it, is seen as domestic violence within Section 177, so that the victim is automatically homeless. That is a clear and workable scheme. The alternative solution of the local authority, where housing officers juggle Section 175 reasonableness in one hand and Articles 3 and 8 in the other hand, trying to reconcile them, is much less clear and workable. It's not just that the local authority officer will be juggling two different legal tests with all the risks that entails. It's that the reasonableness test in Section 175 is a very poor starting point.
Well, I think time is really beginning to run against you very much. We'll obviously hear from Mr. Dravel in answer to that very particular point. But is there any final point you would like to make before your time runs out?
Just very shortly, standing back from the concession made by the local authority that where there is a breach, accommodation ought to be provided by the local authority. Standing back from that and looking at it more broadly, the duty on the state is to take all reasonable measures to protect women from Article 3 conduct derived from domestic violence, and also Article 8 conduct. What is a reasonable measure is a question for the national authorities, CBEV Aqua, including the courts. In our submission, it is plainly a reasonable measure to treat victims of psychological domestic violence in the same way as victims of physical violence or threats of physical violence. The central government of this country asserts it's a step that can and should be taken. The local authority itself accepts it would plainly be wrong not to accommodate a woman subjected to psychological abuse that breaches her Article 8 rights. Move on accommodation is absolutely critical, see the Home Affairs Committee and Bond, and there just is no sensible justification for treating those women differently. Those are my submissions. Thank you very much.
Well, Mr. Drabble.
My Lord, to echo remarks made several times yesterday, our case is simple. It's essentially fourfold. Firstly, we say, on a standard approach to statutory construction, the word violence in the relevant phrase in section 177, subsection 1, which is domestic violence or other violence, means physical violence and does not extend to psychological abuse, however defined. We say this for precisely the reasons given by the Court of Appeal in this case and in Dinesh. This first proposition is an invitation to the Court to adopt what might be called a black letter construction approach to the wording of the statute. But I do that without apology, because the provision falls to be construed as part of the overall statutory scheme, and it plays the role it presently plays only following the post-Pulhofer amendments. Second point, the role of section 1771 in the overall scheme, which is one of what I've called a deeming provision, perfectly happy with the concept of a passporting provision, removes the need to produce a different result by any doctrine of construction such as the construction of the statute as a living instrument, or indeed section 3 of the Human Rights Act. We say that the statutory scheme assumes that the interests of abused women who are not subject
Can
to...
you speak up a little?
I'm sorry.
You're rather muttering to your...
Yep. We say the statutory scheme... Sorry, let me start that proposition again. The role of section 171 in the overall scheme, which is one of a deeming provision, removes the need to produce a different result by any doctrines of construction such as that concerning the evolving living instrument, or indeed section 3 of the Human Rights Act. We say that the interests of abused women are protected by the operation of section 1753. Thirdly, this perspective is reinforced by the legislative history. As we explain in our printed case, and as we've seen already today, the present scheme can be traced back to the Housing Homeless Persons Act 1977. In its early form, the reference to violence plainly meant, we say, on a standard approach to statutory construction, actual physical violence. This has remained the case ever since. Indeed, the latest amendments made in 2002 were worded in a way which indicates that the draftsman was plainly contemplating actual physical violence. I'll explain that again when we come to look at section 177(1)(a). And finally, importantly, the Secretary of State has a power in section 1773 to define a further class of circumstances in which it's deemed not to be reasonable to continue to occupy the premises.
And do you accept that there isn't an equivalent power at section 198?
I do.
Oh, and in the other examples of the Part 5 of the Act?
The other examples. I do accept. I have looked at and do accept it in relation to section 198.
Yes.
But we say, for the reasons given in Dinesh, 198 was the very provision construed in Dinesh.
Yeah.
It's crystal clear that the references to violence are references to physical violence. And the difference in result may not matter so much, because by the time you're dealing with a 198 situation, the parties, the married couple, whatever the parties were concerned with, are separated. There may be some scope for psychological abuse, but it's not impossible. Indeed, we say it is correct that Parliament intended 198 to operate in relation to actual physical abuse. And we say that if any adjustment of the deeming provision, as I call it, is thought to be necessary as a matter of policy, that can be done, at least in relation to section 1771. And this is the more desirable route. We say there is a need for a clear test to be applied by housing officers, and even having heard the submissions today, I repeat that none of the three parties arrayed against me have produced anything resembling a clear, workable test to be applied by housing officers. Again, as we say in our printed case, no part of the argument advanced on behalf of Hounslow seeks to diminish the importance of preventing women from having their lives blighted by psychological abuse. Our case is not to downplay the very considerable seriousness that psychological abuse can present. We simply say, if on the facts it's actually unreasonable to continue to occupy the premises, the housing officer will so hold under section 1751 without the benefit of the deeming provision. In particular, if evidence is presented to show that further, the evidence presented does indeed show that in some contexts the reference to domestic violence will include a reference to psychological abuse, but those are different contexts. The question is what is meant by the reference to domestic violence or other violence in section 1771. So, my Lord, can I go first of all to the decision that's under challenge, because consideration of the decision under challenge does indicate the nature of the problem that the court is being asked to consider. Your Lordships will go, my Lady will go, to the appendix at page 37. First of all, can I just indicate that if the court goes to the end of the review decision, page 42,
Sorry, I'm not. It's my fault for not being quite sure what we're looking at. We're in the appendix.
The appendix is in the bound volume.
Yes.
4 volume.
Page 42.
And it's page 42.
Oh, it's 42. I'm so sorry. Yes, I've got it. Yes.
It starts at page 37.
Yes.
That's probably what I said.
Yes, I got it.
But I'm asking your Lordship to look, and my Lady to look first of all at page 42. Sorry, yes. And the court will see, 2/3 of the way down the page, there's the underlined passage that on the evidence and facts available before the panel in reviewing this decision, the panel accepts that it's reasonable for you to continue to occupy the council tenancy at 88 Belvedere House, thus not rendering you not homeless as defined in section 175 of the Act.
Yes.
So the clear finding of fact that it is reasonable to continue for the appellant, or was reasonable for the appellant to continue to occupy the premises. No rationality challenge has been made on that decision, nor is it alleged that the council have left out of consideration any considerations such as the difficulty that might be alleged when applying to the courts for a transfer of the secure tenancy or for injunctive relief. It seems unlikely that those arose on the facts at all. So what is being said with crystal clarity in this case is that a housing officer who rationally concludes that it is reasonable for the appellant to continue to occupy the premises should nonetheless have found that she was entitled to the deeming provision in section 1771 and would therefore be passported past the adverse finding of fact. When we look back at the rest of the decision, the court will see that the review panel very carefully considered what the issues were in terms of the quality of the relationship between Miss Yemshaw and her husband. And won't spend a lot of time on this, but if we go back to page 39, halfway down the page, there's a summary of what was told, what Miss Yemshaw told the caseworker. That you felt that the relationship with your husband had broken down, that he was no longer close to you. You felt this had happened since the birth of your second child, and your husband had been sleeping in a separate bedroom. You suspected he was seeing another woman. At no time during the interview did you inform the caseworker that you had experienced domestic abuse at the hands of your husband, but you stated that he shouted at you on occasions. And then at the foot of the page, the panel recorded the fact that in making this decision, the caseworker was satisfied that it was reasonable and suitable for you to continue to occupy the above property, and there was no evidence before the council that it was probable that returning to your husband's tenancy would lead to threats or actual violence. And then the passage that starts the panel's reasoning behind the decision, and the panel recite the fact, the second paragraph under that heading, we considered the point raised by your solicitors that you have suffered from depression due to your husband's controlling behaviour in the past and have considered taking your life in the past. And we note that you did not give any such information to your caseworker during your interview. And at the foot of the page, they say, we have looked carefully at the submissions from your legal representatives in relation to the probability of violence if you return to your home while seeking alternative accommodation or legal remedies on the grounds that there has been a marriage breakdown. And they say they noted a contradiction. And then there's another finding of fact. We are of the opinion that your husband may be upset that you left the property with the children, but do not believe that this would lead to probability of threats of actual violence. We apply the statutory test to probability of domestic violence and as to whether it will be reasonable for you to continue to return to Belvedere House while seeking legal advice on your matrimonial rights in the accommodation. So they're aware that there may be legal recourse open to the appellant. They take that into account, and the question they pose to themselves is, first of all, the 1771 question, probability of domestic violence, and separately, the question of whether it was reasonable for you to return to Belvedere House, the 1753 question. And we have seen that the answer that they give to that is it is reasonable for her to continue to occupy the premises. And the third paragraph from the end on page 41, we note that your root cause of homelessness is not that you fled after a domestic incident, your decision to leave the matrimonial home because you felt that your husband did not love you anymore and was not close to you, in addition to suspecting that he was seeing another woman. It appears from the information you gave to the caseworker that your husband's expectations of you as a wife may be high, but this is not an uncommon problem in relationships. Now,
Do you accept that the panel was requiring physical violence?
yes.
You do?
Yeah, yes. Oh, yes.
So, because looking at the issue in the statement of facts and issues, it makes no reference at all to the facts of this particular case. It's expressed in entirely general terms.
I completely accept it. The case has been presented to your lordship and my lady on the basis that the point of the legal issue that needs to be determined is that identified in the statement of facts and issues.
But we do.
But you
Even
do it
in this
against the
court,
background.
I think we decide cases by reference to real facts
Yes.
and not imaginary facts.
Yeah, well, and the reason I'm going to this, to the actual facts, is that in my submission it really demonstrates the fundamental problem that Malone friends face, which is that they have to justify a system in which it is perfectly rational, and it's accepted to be perfectly rational on the facts of this case, for the housing authority to decide that it is reasonable to continue to occupy the premises, and a system which would deem it to be unreasonable because of some psychological violence. And that's where the threshold issue becomes of crucial importance. because it would make perfect sense if the housing officer was supposed to ask the question that the Law Commission asked: has there been psychological abuse of a sort which leads to significant harm? But that's not this case. No one suggested that there had been significant harm on the facts of this case. That, no doubt, is the reason why the appellant and the Secretary of State's threshold test is: does the psychological abuse cross a minimum standard of severity, whatever the phrase is in Lord Justice Richard's judgment in the immigration case? And I put down this perspective immediately, that if the threshold were a high test, such as that set in the Law Commission's paper, then you would always get a favourable answer under Section 1753, unless you really could rely on the family court remedies to prevent the abuse. What's effectively the case that's being advanced by the Secretary of State and Miss Leaven is an invitation to the court to hold that once the abuse has crossed a minimum standard of severity, then whether or not it's reasonable to continue to occupy the premises, the deeming provision kicks in. And we say that that's simply not the way the scheme is constructed. So, can I then go straight away to the text of Section 177 as it presently stands? I'll say something about the legislative history in due course, but if we can go to Section 177 in its present form, tab 5. We've obviously looked at this already this morning. The present text is that it's not reasonable for a person to continue to occupy accommodation if it's probable that this will lead to domestic violence or other violence against him. Pausing there, our straightforward submission is that the word violence means the same thing in domestic violence and in the reference to other violence, actually within the square brackets, because those words are inserted by the 2002 Act. On the text that's been produced by the 2002 amendments, we say that is really put beyond doubt altogether by Section 1771A.
Capital A.
Capital A, yes, indeed. And I respectfully adopt the observations that were made during the course of this morning, that the structure of 1 capital A is to define, first of all, the word violence, and I repeat that lends support to my proposition that the word violence means the same in both its occurrences in Section 1771, either after the word domestic or the word other. 1A defines violence in both those contexts as meaning violence from another person or threats of violence from another person which are likely to be carried out. So pausing there, we have a definition of violence. Pausing there too, I say that the natural meaning of that phrase is that violence from another person means physical violence from another person. And a strong indicator of that is the concept of threats of violence from another person which are likely to be carried out. Because I accept Ms. Leaven's concern that the concept of threats of violence is not easily transferable to threats of psychological violence. No doubt it's possible to think of some examples. The threat that you will be locked in the house without food, without any physical violence, would be a threat of psychological abuse. Avoiding the word violence for a moment, I accept that that is possible, but I still repeat the submission that the natural meaning is that you are looking at either actual violence, in the sense of physical violence, or threats of actual violence from another person which are likely to be carried out.
What about rape, Mr. Travel?
Well, that's violence, even
No.
with consent. I don't have any difficulty
Rape
with that.
is violence, even though there is no actual assault accompanying it. It's achieved the lack. It's having sex with a woman without her consent.
Well,
She's asleep. She's drunk.
well, I remain in my
She's oppressed.
submission.
She submits because of oppression.
I repeat my submission. I remain entitled to answer that at two levels. There would be a powerful argument that actual physical assault, which is what your ladyship is envisaging, even in that situation, because there's no consent to the physical contact, as I understand it, no effective consent to the physical contact, is violence. But even if that were not the case, it's the classic example of the extreme case of something that's might be labelled psychological abuse but doesn't get into my reading of physical violence, which would be almost inevitably lead to a finding that it wasn't reasonable to continue to occupy the premises under section 175(3) unless the remedies available in the family courts could genuinely be relied on to prevent the recurrence of that sort of rape. So I mean, one of the characteristics of the way the argument has gone is that I keep on being presented with extreme examples of psychological abuse which would undoubtedly cause harm, but their very extremity strengthens my ability to rely on section 175(3). The conjuring trick the other side have to pull off is why we need a deeming provision. Mr. Naffler supplies the answer to that. It's to avoid the need for a high threshold question. I mean, that's exactly his case. You get into 177, he wants 1771 to avoid the housing authority being able to make a broad judgment.
It's also to protect the housing officers and, of course, the applicants, the claimants, from the risk of error.
No.
But a housing officer may not understand just how serious it is if a mother who has already been deprived of resources with which to buy for herself what her children need and what she needs is threatened, is not allowed, therefore, to make those sorts of choices, and is then threatened with her children's removal. I'm not saying that's the facts of this case.
No.
They come quite close to that, on one view. Anybody who's had anything to do with victims of domestic violence know that that is a relatively, it's not an extreme example in the sense that it's very serious, but it is not extreme in the sense of rape or some of the other things. The effect that it has on the woman in terms of terrifying her and keeping her under control is very serious.
Yes.
But not all housing officers are going to know that.
No. Well, I completely accept that, both as to the seriousness of psychological abuse and the seriousness of the woman's concerns about losing the children and potentially losing the children in their situation. I accept that, and I also accept the housing officers will not necessarily appreciate that. But the question for the court is how much that's solved by adopting a wider approach to the deeming provision. I have no doubt that housing officers need telling loud and clear of the dangers of assuming that the woman could continue to occupy the premises whilst resorting to legal remedies of the sort that your ladyship spelt out, if I may say so, with clarity in bond.
I've been going downhill ever since, yes.
I completely accept that. But I mean, we come back to the threshold point. How long are they only going to be helped if they're told with clarity what threshold they're looking at for the application of the deeming provision? And unless somebody produces an answer to that, then in my submission it's better off leaving the Secretary of State to either make the order or to produce references in the code as to how these situations should be dealt with under 1753, policed by the courts if the housing officer does make a basic error, or any error. That's the way forward.
So, supposing that the tests were widened in some way, as has been suggested, and just suppose that in practice the officers could work that test. I mean, do I understand you have a second point, which is that it takes out of 1772 a class of cases which is in 1772 at present. Is that right? Am I wrong?
Yes. Well,
I mean, because it puts more into the passport.
It puts more into the passport. That would not concern me if the threshold were high enough. Well, I would say high enough. I'm not arguing for a kind of completely unreasonable threshold.
No.
But if one adopts, for example, Mr. Naffler's approach, no threshold, you just have to find something that is a controlling or bullying behaviour, and without any investigation of seriousness, that's enough, then I think the 1772 argument does come into play. You've got to set the threshold at a point which justifies taking the class out of 1772.
Yes. But is there not a threshold for physical violence as well? And just the occasional push or slap. Does that? I mean, is it just one slap will do, or what? What do housing officers apply?
I'm sure that they do apply some form of seriousness threshold, but it's certainly not at the level of the Law Commission report, for example, in paragraph 62. It's violence from another person or threats of violence from another person.
Well, the word violence itself has a connotation, doesn't it? You wouldn't regard just a push, perhaps, in a moment of anger, just one push, as amounting to what would really be described as violence if it happened only once, and there was an apology immediately followed, and so on.
No, I accept that, and I think probably on the basis of the judgment in bond, if we actually look back at page 41 of the appendix, as to what is this?
41?
Yeah.
In the appendix, yes.
In the appendix.
Sorry, where are we?
41 of the appendix.
Oh, sorry.
What I wasn't quite clear about just reading this was how much. I mean, what was said about the psychological? I mean, what was actually being was that really being submitted to the council? I mean, it's not very clear from the thing which is the letter 33 and 4.
No. The panel's view of it is summarised on page 3, as your lordship will have seen.
Yeah.
In the other appendix, I'm not sure Can I try and actually answer that after lunch? I'll try and,
Yes.
There are two interviews, weren't there?
Yes,
There was
there
an
are.
interview on the 27th of August,
yes.
which is at page 119 to
122.
122. And then there was another interview 2 days later on the 29th of August, which is at page 143,
I'm not sure it's correspondence. It's found its way into the
148.
appendix.
I think the solicitor's letter asking for the review after the decision letter is
That is quoted
at
somewhere.
33.
That's three.
But the raw material is those interviews, isn't it?
Yes, yes.
I mean, everything was based on those
Yes.
interviews.
Yes.
Yes, yes. Anyway, the point I was making, just very shortly, off page 41, is that the approach is that the review panel applied. Second paragraph on page 41 is we applied what they call a statutory test,
Yes.
a probability of domestic violence. And as I say, I think that goes back to the idea that one was looking in Bond, that what one was necessarily looking for was whether it was probable that there would be violence in the future. And if it was, then it was right that the deeming provision plays the role that was envisaged to be correct for it in the scheme.
Well, the statute uses the word probable, and in practice, the housing officer is going to expect to have quite a long list of incidents of past violence to use as a basis for predicting what is probable.
What will happen in the future. Yes, I was looking at one trying to find probable, but it's in the very opening words. Yeah. That's not quite an answer to Lord Hope's point about what is the threshold for whether something is or isn't violence in the first place. And I would accept the minimum level of seriousness.
Well, if unbelievably the complaint was based on one push or slap, it wasn't going to get very far with the housing officer.
You wouldn't get past on that fact, you wouldn't get past probability for future, because your lordship's entirely correct that 1771 is forcing one to look at what's going to happen in the future and whether in the light of what's going to happen in the future it's reasonable to continue.
Yes. I mean, in 1977, presumably, the real question, is this the sort of chap who knocks his wife about? That's really what it came to, isn't it, in those days?
In 1977?
Yeah.
Yes, that's very much, yes, I mean, for all that some trepidation about making this observation. But there is a certain danger of assuming that in 1977, the statutory drafting of the 77 Act was picked up any wider approach to the concept of the danger of violence in the home than was meant by actual physical violence. So I'll show your lordship and my lady some passages in the code which make that good. Purely anecdotally, the current law statutes annotations on 177 record Lord Gifford complaining that not on 177, on the 1977 Act, record Lord Gifford complaining that the formula in section 1 of the 1977 Act might require wives to show their bruises. That is very much the flavour of what was happening. And I unashamedly make the submission that when it actually goes to subsection 1 of 77 Act, that whatever the wider background, it was envisaging physical violence. So, my lord, my lady, for those basic reasons, which is to do with the structure of 1771 itself, we submit that the references to violence in either the context of domestic violence or other violence are references to actual violence. Those reasons are substantially the reasons that led Lord Neuberger in Danish and Lord Justice Etherton in the present case to form the same view. And if your lordships will just look shortly at the Court of Appeal judgment in the present case, which is the very front of the appendix in the core volume, page 3. The judgment sets out Lord Justice Newburger's judgment. The learned friend has taken the court to that passage already at page 7, paragraph 14 through to 19. I completely accept that part of that reasoning is dismissing a submission that doesn't arise on the facts of the present case, i.e. a submission that the word violence would incorporate a common law assault which put you in fear of violence rather than leading to actual violence. No submission like that is made in the present case, but the stress in paragraph 15 on the natural meaning of the word violence applies here. And
I think that's got somehow or other a bit muddled, because I think what Lord Newburger must have been saying was that an acontextual meaning of a word is not. Isn't that right?
I completely agree. I've struggled with that too.
Yeah.
I think he means a meaning of a word out of context.
Exactly.
It's not it's not a safe basis.
It must be.
Yeah.
Must be in its context. Yeah.
But I do submit that the natural meaning of the word violence out of context is that which Lord Newburger identifies in paragraph 15. When one puts that thought together with 1771 large A, the structure of 1771 large A, as we've already identified in our submission, that becomes overwhelming. And then there's the reference to the Homelessness Code of Guidance for Local Authorities, July 2002. Repeat the submission that we've made in the case, that code is virtually contemporaneous with the 2002 amendments.
Can you be a little more precise? Which came first?
I am pretty sure the code followed the statute, but I don't actually know that. And I'm saying that because in passages which are not in front of the court at the moment, there are references to the provisions of the 2002 Act put in. So I think
see.
it postdates.
Yes, that would fit.
Yeah.
Yes.
I'll try again. I'm reaching up here. Secretary, the all-knowing Secretary of State. There's the answer.
Yes.
Right question. But I'm not making a very taut point on construction. But if we're going to have arguments, and we haven't had actually much today about which version of the code most clearly explains what the effect of the 2002 provision is, then it is the 2002 code.
If you look at paragraph 6.16 of the 2002, code, that refers to domestic violence or other violence.
Where do we find that?
This is in 12.
I think.
And so that tends to bear out your
There's no doubt
point
that the code was dealing with the law as it either stood or would stand after the amendments made by the 2002 Act.
The 2002 Act was the seventh statute of that year, so I think it was probably been passed several months before.
Yes.
That seems reasonable. Yeah. And indeed, I think it's likely the very nature of a code is that it's explaining legislation rather than being a white paper or a green paper indicating what the policy intention is.
It's often been drafted before the...
It's often been drafted before, and it may have been consulted on before. I mean, that sort of situation does arise. And
Sorry, we haven't looked at the 2002 code. Which paragraphs touch on this?
Well, 6.16 refers to 1771A, doesn't it?
That was why I was simply drawing attention to the fact that it refers to the Act as amended rather than... in its original version.
I was going to take your lordship and my lady very shortly to the 2002 code in any event, so not at any great length.
Page 9 of the appendix quotes the
Well,
2002 code.
Mr. Chairman, I wonder, in view of the time, whether we might enjoy that
Well, indeed.
visit after
That's
lunch
what I was thinking.
at 2 o'clock.
2 o'clock.
Quite right.